Okay, great. Looks like it's working. All right, so let's get on the record. Start this hearing off. It's docket 6690 UR 127, the application of Wisconsin Public Service Corporation for authority to adjust electric and natural gas rates. This is Mike Newmark, Administrative Law Judge for the PSC. We have parties and commission staff in attendance on Zoom. Don't see any members of the public connected at this point, but this is for the parties. Members of the public are welcome to observe over Zoom or our YouTube live stream. So just wanted to give a bit of the details here for our process. And I do have the notice of hearing on the screen. It's going to switch to the second notice that we've issued that will display our public hearing on November 1st at 2 p.m. and 6 p.m. at the Neville Public Museum. Also, public comments in this case will be due at this point Thursday, November 3rd, through the Commission's website and by U.S. mail. I think we have 21 comments filed so far in the case. So, oh, we lost someone here. I'll adjust that later. Okay, so that's our basics. We also have the service list document I had shared with parties, and we can go off the record for discussion of the service list. So just displaying that on the screen at this point. This is a document I shared, I don't know, it was Monday, Friday, I can't remember. And I just want to display that on the screen, but it's the contacts we'll use to serve the order in the case and what parties should have been using to serve the documents to each other. Any corrections or additions we need to make to this list?
Yes, Your Honor. This is Lucas Fikes on behalf of Renew Wisconsin. My name is not on the service list. Lee Ewing from our law firm is on that list. His name should be replaced with mine.
Okay.
An address.
And do I have your information on file? I don't know if.
The information should be the same as listed for Lee Ewing, with the exception of my name.
Yeah, I think just so I have it clear, can you just file a brief notice of appearance, just and I can switch that out once we have it in documented on Earth.
Sure, it should have been included in the initial motion to intervene.
Okay, then I can add it in as long as it's on file right now. That's fine.
Okay, thank you.
Yeah, all right. And if I forget, let me know. I'll have to get that email to the court reporter as well, so she can serve the transcript. Okay, so anything else with the service list? Anyone else have a problem with that? No? All right. So then we can move on to offered evidence. We do have fairly long list here. I'm going to increase the screen size here. I don't know how that will affect what you see, but change things a little bit. So offered evidence list, that's another document shared with parties before. And just want to be sure, let's see, so this may be a lot more involved asking this question than usual, but additions or corrections to the list. I know I did note that there's been a settlement agreement filed in the case. I think we can discuss how that'll end up in the record at this point. I had made a note to myself that we should refile it as an exhibit just so I can receive it into the record. The timing of that, though, we can discuss. Besides that, I did incorporate, since the document you received, I did incorporate errata and revised exhibits that were filed yesterday. But any mistakes that you noticed on the document that I sent out?
Judge Newmark, this morning, the applicants filed brief source rebuttal for Ms. Bulkley and Ms. Keller.
Okay, let me check that. I did not see that in yet. So maybe this is something that got lost in the mix, but so the facilitating matters order for Zoom sessions, it does direct parties to share documents it'll use at the hearing, to email those documents to parties, staff, and the ALJ. It's supposed to be a day before the hearing. So we can discuss, we'll ask about whether people had time to review this source rebuttal, but I didn't get a copy yet. So if it's on IRF, it may not get posted exactly at the time it's filed. So
yeah, Judge Newmark, we filed it as a courtesy to the parties in lieu of just having it delivered orally on the record. But our position is that it should be received in if it were read in.
Yeah, I wasn't asking for position on that. I just need to see it. So if you can email it to me in advance when you're serving to parties, that's what's intended by that. At the least, what's intended by that additional requirement from the facilitating matters order is that I get a copy by email, because you can't bring it to the hearing. So, so I do see it on IRF. It just got posted a few minutes ago, but we can discuss how we'll handle that once we get past the nuts and bolts here. So, all right. So that's Keller and Bulkley. Am I saying that right? Bulkley?
That's correct.
Okay. And anything else with the list we need to discuss?
Judge Newmark, with respect to all your comments, obviously the administrative things we'll address. We also have our witnesses prepared to address the substantive questions you posed as they appear.
Okay, thanks. And corrections to the list? Anyone? Okay. All right. Yeah, we can. So let's talk about some of those. Let's talk about some of those questions I had. I guess just wanted to make sure that if we have the witnesses confirm they understand what I'm asking for, like especially Bulkley, there's a couple of exhibits I'm asking for the witness to provide. So I just want to make sure they can confirm that they're able to do what I'm asking. So that'll be part of the questions, because otherwise it's just refiling for filing misfilings, which I'm assuming you're agreeing to do that at this point.
Yeah, and you want the witnesses to address that as they are sworn in, right?
Yeah, if they can.
Yes, they're prepared to do that.
Okay. All right, nothing else? All right, so I think we have this buttoned down pretty well. So I just want to get on the record just to confirm the offered evidence list, the way it stands right now. So let's get on the record. So we discussed the service list, and I'll be making one change to add Lucas Fikes to the service list. We'll also discuss the offered evidence list. And as it was shared to parties prior to the hearing, there are no corrections for the list. I did add what I had received by yesterday, the errata and revised exhibits. So those are also reflected in the current list. So let's talk about the source rebuttal from the applicant, Bulkley and Keller. And also there's Keller Exhibit 3, which we're going to need to well, we can accept that as Keller 3. To change my comment here. So the source rebuttal and exhibit that was provided to parties by email, is that correct?
Yeah, that's correct. Filed on earth and served on parties by email.
Okay. So did parties and staff have enough chance to review those documents? Do they need more time? So anyone can chime in here.
CUP could use a bit more time.
A bit more, okay.
If we have 10 minutes
Okay.
to just briefly review and discuss it, that would be helpful.
Okay, so I think that's probably just the best thing to do at this point. We can take a beat and have you review. Yeah, so let's just do that. Anything else we need to discuss? I do want to go over who we have questions for, which witnesses they're actually cross-examination for, or who can we excuse without appearing. So let's do that first. And I know parties did send their preview of that to me, but things may have changed since then. So let's just go through the list here. So I'm assuming Bulkley will be testifying. Dukas, I have questions for, I believe. I think so. Yeah, I think that's. You have a question for Dukas. Graves. Anyone have questions for Graves? No. Keller, I'm assuming yes.
Yes,
Yeah.
Your Honor, the PSC will be having a cross-examination question for witness Keller.
Keller, yes. Yeah. Okay. And Korduki, I have questions for. Nelson, you have questions. Pecorello. Yes. Shipman, any questions for Shipman? Okay, Stasic, questions, Skunk, questions. Maybe those are refund. Anyone have questions for? Yeah, I do have that.
CUP has a question for Mr. Stasic.
Or
Stasic, you're saying?
Yes.
Yes, yeah. That's all I have so far is Shipman. No questions for Shipman.
Oh, I'm sorry.
That's okay. I'm going through it pretty quickly. I'm sorry, but I don't want to spend a lot of time on this. Kime, there's questions for, I'm assuming. I don't have any. Singletary, there's questions for Singletary.
Yes.
And I guess I don't have any questions for Kime. So does anyone else have questions for Kime?
Yes, the applicant does.
Okay. Tetzlaff, I have a question. No, I don't have, I have an issue with that. Barnes, any questions? Excuse me, Kel? No, Vickerman?
Your Honor,
Yes.
for renew witness Kell, we still plan on doing the attestation on the stand, but
Okay.
for Vickerman, if there's no questions, we'll submit that after the hearing.
Okay, and Barnes, I'm assuming you'll do that by affidavit too. How about Walmart? No. Kronar or Teague, any questions for them? Bauer and Manny.
Your Honor. Oh, And
Yeah.
and you have, I'm sorry, this is Steve Heinzen for we. You have questions for both Bauer and Maney in connection with cost of service and revenue allocation?
Oh, I think I've deleted those, I believe. I don't. Oh, yeah, okay, there's the one, this one for Bauer, yeah. Manny. I think just for Bauer, I think Manny's questions, I deleted those. So anyone else have questions for Manny?
And just to make sure that I understand, at the very end of, sorry, at the end of the offered evidence list, there are, you note that there are questions to the most appropriate witness in connection with revenue requirement, cost.
Mhm.
So is that what we're talking about right now? You no longer have questions to understand where Maney's position on that is?
Oh, you're right. Okay.
That's what really I'm at, yeah.
Okay, yeah, I had some specific ones that I got. No, I guess we should get her take on that too. Yeah.
Okay,
Sorry about that.
okay. Thank you.
Your Honor, I apologize. This is Barry Nom for Walmart. I guess the same question would apply for Walmart's witnesses. Do you require them to answer those same questions?
Well, I guess I suppose the settlement agreement handles question 1A, the position on, the revenue requirement cost service study. If it covers that area, then they probably don't need to state the parties' positions, but I'm not sure. I guess I wrote that before I knew about the settlement. So,
And Your Honor, this is Cindy Smith on behalf of the commission staff. I want to make sure we're all kind of on the same page. The settlement agreement currently is not in
Oh,
this
right.
record.
You're right,
So respectfully, I think to the extent parties have anything to say on these issues, they should say them.
yeah,
And,
that makes sense. Okay.
And then the questions, all the questions today are not going to be directed towards the settlement. And we are, at the conclusion of the hearing, we can follow up, Your Honor, with your question about timing and
Right.
submittal to the record. So just to be clear, everything's kind of fair game today, except the settlement.
Right. Yeah. Okay. I agree. So yes. So let's go back and let's just double check we have everyone. I think we have the company covered in terms of do we have the company covered in terms of those those questions, the
Yes.
positions and cost service study. Yeah. Okay.
Newmark, one question on the company witnesses. I didn't hear anyone have questions for Mr. Graves. And I believe your
I think you're right.
were administrative, so.
Okay, your audio is cutting out.
Sorry.
Okay, so let's see. The only people we have. So yeah. So we need for the questions here. We'll need a Walmart witness for the questions posed to everyone. So who should we use for that?
Your Honor, for question 1, that is a question for Mr. Teague regarding the cost of service studies. Witness Cronauer is the witness that testified to questions regarding ROE.
Okay. So we'll put them back in the mix. All right. Bauer, Manny, back in the mix. Commission staff, I'm assuming you'll have them verify testimony live, or we have someone to excuse.
Yes, we'll be verifying testimony live.
All right. So that didn't really excuse a whole lot of people. Okay. Sorry about that. Thought I'd give people a break. But Barnes can be excused. So let's get on the record and just handle this. So we did discuss which witnesses there's no cross-examination for, And we have witness Graves, Shipman, Barnes, Vickerman, and that's it. No cross-examination, so we can excuse those witnesses and expect refiled corrections and an affidavit verifying testimony to be due in the appropriate time. All right. So with that, I don't think I mentioned, I can accept the documents that are filed that appear on the offered evidence list for the record pending verification of the parties and staff. Let's also then discuss there's a couple of questions I think we need to review. And it deals with the IUOE witness. Is it Tetzloff? Just get that up here on the screen. Okay, so so besides the technical corrections that I'm asking for surrebuttal, I guess there's also just page numbers for rebuttal. Surrebuttal, the witness does make a statement with respect to ROE, and I don't know if we have witness available here. The screen is not big enough to show it. The person is here. Okay. So let's first just confirm in attendance right now. We have Wisconsin Public Service. We have Clean Wisconsin, Cub, Renew, Roundy's, Walmart, WIG, and commission staff, but the IUOE is not in appearance at this time. So this is a indication I was going to have the witness strike the testimony with respect to ROE for lack of foundation, probative value, and being unduly repetitive when it gets combined with all the other ROE testimony on the record. And since that person is not in appearance today, they did get this this file prior to the hearing, but so I'm going to have them refile in that way, or I'll go ahead and file a document that strikes that testimony if one isn't forthcoming from the party. So I just wanted to make sure we're clear on that. And there's also a message that I gave at the bottom of the page here to strike references to witness Ellis's testimony that's been filed in docket 5 UR 110. I know this deals with the ROE issue, but we're not really blending these dockets together. I don't really know the basis for doing that at this point, and it's not appropriate. So does anyone want to speak to that?
Your Honor, from the applicant's perspective, I think that was actually a drafting error, so we've got no problem striking it from the Bulkley testimony.
Okay, all right. Oh, I also wanted to mention we have two files that I'll be filing as exhibits. It's the decision of the Arizona Corporation Commission related to Arizona Public Service that's been discussed in the record, and also the petition, I guess the petition for review from Arizona Public Service Corporation challenging that decision. Just to provide context, that decision's come up quite a bit in the case. Besides that, though, I think we can move on to taking our 10 minutes to review testimony. So everyone on board with that?
We're actually, Your Honor, we've had enough of an opportunity in the meantime to review the testimony, and we're fine proceeding.
Okay, I haven't seen it yet, so I was going to piggyback on you. Let me just check how long this is. Okay. Yeah, I do want to take a minute to look at that. So let's just recess for 5 minutes and just come back in here at 10:35. Should be ready to proceed from there. Okay, let's get back. So I did have a chance to review the SIRSA rebuttal. And let me ask if there are any objections to receiving those documents in writing rather than having them read into the record. Wait a minute, there's some people not connected yet. So I'm just asking for any objections to receiving the SIRSA rebuttal in writing rather than having them read into the record. Okay, great. All right, so we can do that. I'll accept those for filing. In my review, I didn't see any filing corrections, but I'll take a closer look later. Hopefully there's nothing we need to deal with. Otherwise, I think we're ready to go.
Your Honor,
yes, go ahead.
If I may, I had a quick question regarding references to Mr. Ellis's testimony in this docket. There are also some references to 5 UR 110 in terms of reflections on Cub's ROE recommendations in that docket, particularly in Ms. Buckley's rebuttal. So should those also be removed?
Okay, that didn't cross my, I didn't notice those. So where would we find those?
So it's actually in her rebuttal. One is on page 5.
Looking at witness Buckley's rebuttal.
Correct.
Okay, so let's go off the record just to review that.
So it's
same page 5.
Yeah. The last bullet point. Which is further discussed later in the testimony. There it is.
And is there any other references?
There is more discussion of that later in on page 56.
Yeah, that's good.
And 57.
Okay. I mean, I guess the fact that we have an ongoing proceeding may not be the same concern I have, but so I was comparing. Oh, right, he's comparing. I think in this situation, okay, so let's get on the record. So there's a question from Cub's attorney with respect to witness Buckley's rebuttal testimony and the references to witness Kimes' testimony in docket 5 UR 110. and whether that should be stricken in in alignment with my striking witness Ellis's references to witness Ellis's testimony from 5 UR 110 in this docket. I think in this case, I'm going to allow those references to, I'm sorry, to say Mr. Singletary's testimony.
That's correct.
Because he is a witness in this case. And I think comparing the specific comparison that witness Bulkley is making is valid to be introduced and offered in this case. And witness Singletary has an opportunity to he both provided the context for the criticism witness Bulkley has made, and witness Singletary can address and rebut that the claims that the comparison that witness Bulkley is making here. So I'm gonna allow that to remain in the record at this point. Any other questions about that?
None from Cal. That makes sense.
All right. Okay. I feel like there's something else, but we're just gonna plug ahead because I don't know what else possibly do here. Oh, I did want to mention that I believe we've noticed this hearing as an open meeting because we're expecting the possibility of more than one commissioner to be in attendance. So do welcome them and also invite them to ask questions. Just turn on your screen and let me know, and certainly we'll take your questions promptly. So let's get started with the applicant's witnesses. Have you call your first witness.
Thank you, Your Honor. The applicant calls Ted Idukis.
Okay, so we're still not hearing you very clearly.
The applicant calls Ted Idukis.
Okay, great. All right, I'm going to swear you in. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name.
Theodore Idukis, and that's E-I-D as in David, U-K-A-S.
Mr. Idukis, did you prepare and cause to be filed direct and rebuttal testimony in this case?
I did.
Did you also prepare and cause to be filed accompanying exhibits?
I did.
If I asked you the questions in the testimony today, would your answers be the same?
Yes.
Assuming Your Honor, his testimony exhibits are admitted to the record, he's available for your questions and cross.
Yes, thank you. I'm just going to add the witness's name here. Screen. Okay, great, wonderful. Yeah, we have your testimony. Thank you for participating. And I'm just going to try to find my questions here. Okay, so first I just wanted to confirm, and maybe it's my computer is not seeing something correctly, but witness Idukis did make reference to data request response in another docket, and I was hoping we could have him offer that as exhibit 9, and I believe it's still 9. Yeah, and let's just, so what I'm seeing on my version of this, and this is public, we get to the bottom and it's described, part 3 is just, it's left blank, and I don't know if I'm not sure what's wrong with that.
Yeah, I believe that, Your Honor, that was an error in filing.
I'm sorry, who's speaking?
This is witness Idukis.
Okay, thank you.
Your Honor, yeah, that is an error that needs to be corrected by errata. That answer was inadvertently deleted or removed from this version that was filed. The answer would be the same as the version filed in the other docket. So we will have to file an errata corrected version of this with the answer for part 3 included.
Okay, so when you say you'll need to refile, you'll be refiling in the underlying docket.
in
I have to
this
list here. It's the BS docket, I think.
No, this was I thought this was an RR 40
Yeah,
response in this docket.
it's in this docket. Okay, all right, my mistake. Yeah, if you could, yeah, refile. If you could,
Alternatively, I could read that response into the record but I probably,
no, thanks. That's all right. So what we'll do is just have you file the exhibit. I don't know if we need to refile the data request response. Probably makes sense to do that, just so the data request response is complete, and then file the revised data request response as the exhibit.
got it.
All right, thanks.
Your Honor, just a point of order, would that data request response be included in staff's comprehensive?
That's not my understanding, because that's not a personally requested data request. And staff maybe can confirm this, but my understanding is staff is offering, and let's check, they actually have offered this already. So let's go off the record. Let's see. I don't think they include those, but I could be wrong. I'm avoiding the scrolling on the screen share. I'm just checking myself here. So they've included all of the data request responses that are from individual staff, for example, like BL from Brittany Larson's request, but not the ones that come in as part of an application. So no, I don't believe that is already included in the record. So that's why we wanted to make sure it gets in there.
All right, thank you, Your Honor.
Yeah, and thanks for checking on that. Yeah, so I did have one question for the witness.
Back on.
Yeah, back on, please. Okay, so witness Eudukas, just was curious that I noticed that on rebuttal testimony, the IUOE witness Tetzlaff mentions, and let me just bring that up. He does mention the possibility or perhaps the current practice of offshoring customer service personnel. And I just wanted to ask you a question about that. It's just, I have a page number on here. All right, let's get that on the screen here. Fortunately, we don't have page numbers. So it's in terms of the PDF, it's page 3 of the Tetzlaff rebuttal. And he states, well, he makes mentions of contractors who may be utilizing traveler employees from out of state or even offshore resources, as in the case of the customer care center. So I guess my question is, does the company currently use offshoring for the customer care center?
So the company does use a US based company that is a contractor. That company, obviously we don't control where our contractors hire their employees. I do believe that for some credit and collections work, that US based company does employ or utilize employees of its own that are located outside of the US for customer, call center, collections, credit and collections type work, but the company itself doesn't have offshore employees. And I would say, looking at your follow-up question, in terms of the dollars that are being requested in this rate case for our revenue requirement and the FTE, headcounts that are at issue, the company's intention would be to use those dollars to hire employees, located here at the company, not for a contractor or offshore.
Okay, thanks. So just curious though, is there a customer care center in the service territory at this point?
In the what territory?
In the utility service territory?
Yes.
There is, okay. And that handles what operations? What functions does it provide?
Other than saying, other than customer care, receiving calls and responding to customer service, calls, I'm sure a lot of favorable, I would say complaints, but I'm sure they're all very happy with our service. So they're not.
Well, that's not what I mean. Okay. I'm just saying, is it only credit collections that's offshored? Maybe that's
Your Honor, I am not the subject matter expert for this area.
okay.
My understanding is that is the area that is contracted with the U.S. company, and that contracting company may use offshore resources.
Okay, I see. Yeah, I wasn't sure exactly how this testimony was worded, what exactly was the situation. That's why I'm asking. So yeah, and let me ask again the question you beat me to. Oh, where did that go? Huh, why did that happen? Hang on. Okay, no, that's. So let me just go off the record for a second. I had another question about the labor plan, and I was asking that of oh yeah, so I was asking that of is it Zonk? Am I getting that right? Is he the best? Is witness Zonk the best person to answer the whether the applicants have a staffing plan for the test year?
I believe either Mr. Zagans or Mr. Stasek could answer that, but I mean, the answer is yes. But if you want any more detail than that, they would be the subject matter experts to answer your follow-up.
And just generally though, do you know if it's in the record?
Yes, it is. So it would be, well, I know we're not off the record, but it would be, I'm sorry, is it, yeah, so there's a data request response PSC-BS-1.3 does have the most up-to-date info on our staffing plan and reflects the original and updated versions of there's a pre-filed data request response to is RR-71, which I guess we had assumed would be in the record, but we would need to check or submit it as part of the records.
Okay, so but you think the actual documents in BS 2.3?
1.3, Your Honor, but yeah.
Okay. Yeah, so I don't think staff has offered that on its list. Let me just search 1.3. See if it comes up. If KAC 1.3, that's not. Oh wait, we do have BS 1.3. An update to include year-to-date 2022 actual full-time equivalents by month. Okay. So I guess let's get on the record. So I did pose a question to witness Educas on the off the record related to the applicant staffing plan for the test year, and I'm not sure if we're finding it. And then in addition to whether there is one, which there is it in the record? Is the follow-up question, and I don't see it. We're not finding it exactly in a document that we can identify at the moment. So I'm just going to ask if the company could file that as Educas 10, just so we have the plan in the record. Is that something we can expect?
Sure.
Yeah, we can do that.
Okay.
Since that was an individual request, though, it seems that it would be in staff's omnibus exhibit. But If it's not, we can file it separately.
If it's not, or just let me know if it is, where it is. And I guess what I mean by the plan, maybe that may be the confusion. What I'm understanding the plan to be is how the company will plans to fill the open positions going forward in the test year.
I mean, you know, I don't know by council. I mean, in terms of like we have our budgeted, head count plans. I don't think there's like a flow chart or kind of manual laying out how we go about filling those. If that's
Okay, there is none. Okay, that's what I was looking for exactly. Yeah. So is there a policy or a strategy, a manual that says, we're going to fill these positions, we're going to go out to such and such, job fairs, and we're going to post so many applicant, notices, employee notices, things like that. That's not what we're talking about.
I would say that all of the postings are typically, available online and people apply. So, if you wanted a stack of
No, I'm saying, is there a strategy document that says how the company would achieve its goal? That's what I'm.
Your Honor,
aware of.
I guess I would say, without testifying, that the company has obviously an HR function, a recruiting function that employs hundreds of people, and the plan, as far as we know, is to continue to execute on those functions to fill open positions. I don't know that we have not laid out a particular strategy separate from that in testimony anywhere, or as far as I'm aware in data requests. If you'd like a supplemental piece of testimony on that, we could certainly provide it, but it just hasn't been an issue in the case until now.
Yeah. Okay. If it's just something that we can get someone to testify to, that they'll just continue their normal business operations in terms of hiring, can someone do that in this case?
I mean, Your Honor, I'd be able to testify that I know that to be the case, but in terms of so I thought you were asking for a document on that to confirm that.
It doesn't sound like any exists though, right?
Well, again, and I hesitate to say that because we haven't been, as counsel, we hadn't been asked to search for that
Sure.
area. So none that I personally, as I sit here today, I'm aware of, but I haven't searched for it or asked for it.
Yeah, I suspect, Your Honor, that there are lots of policies and guidelines covering hiring and recruiting within the company, but we don't have those as we sit here today.
I understand. That's fine. Okay. So my main question is there a document that outlines how the company will pursue hiring the open positions that are currently being at issue in the case? Is there a document like that?
We will have to. I do not know as I sit here, but we can look.
That's fine. I mean, I can accept that answer that you don't know. That's fine. Okay, great. And should I pose that question to any other witness, or do we have the company's understanding?
I just don't know, Your Honor.
Okay.
We can talk about it.
Yeah.
Only on a break and see, but whether or not there's a plan to do anything different than the company's normal hiring function, just don't know.
Yeah. Okay. That's fine. I mean, what I gets confusing is that there's a term that's being used, a staffing plan, and that's in testimony. There's a staffing plan. I don't know if maybe that's the IUOE's witness using that terminology, which is causing the confusion. But to the extent there is a plan, I just want to know if we have it in the record. That's really what I'm talking about.
Yeah, and Your Honor, I could confirm that term is not one that the company uses. So that might be, you would have to ask witness Tetzlaff about what he meant by that, but
sure.
That is We did not mean, we didn't use that term and wouldn't mean anything by it, but.
Okay, and I probably should have asked that question first. Maybe I was just, there's so many filings here than where they're coming from. But yeah, now I understand what the confusion is about. I think that's, when I see that there's a plan, when someone uses the term a plan, I want to see it. That's pretty much a given. So, okay, I got it now. All right, great. So I don't know if there's any other questions for you. Okay, so do we have any other cross based on my questions? No, how about redirect?
No, Your Honor.
No, okay. Well, thanks very much. You're excused.
Thank you, Your Honor.
Your Honor, you're going to see a little bit of musical chairs among the lawyers. But
No problem. The lawyers are going to change? Okay, let me see.
And I don't know faces, so I don't know who you are.
Good morning. This is James Goldschmidt for WPSC.
Thank you.
Just wanna-
The company will call Ms. Kim Keller.
And is she under Educus?
I'm
Yeah,
going to change that. Yeah. I can't find.
Sure.
Find where okay, there we go. Okay, great. Let me see. Where are you? There you are. All right. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right. Go ahead.
Would you please state your name?
Kim,
Ms.
I'm
Keller,
sorry, that cut out.
Kim Keller.
Ms. Keller, did you prepare or cause to be prepared and filed direct rebuttal and sir rebuttal testimony in this case?
I did.
And did you also prepare or cause to be prepared and filed 3 supporting exhibits for your testimony?
I did.
To the best of your knowledge, were your testimony and exhibits true and correct as of their filing?
Yes, they were.
Are there any changes or corrections that you wish to make to your testimony or exhibits?
Yes, on exhibit WPSC Keller 2, we had some numbers that were confidential, and that was an error. They should have been public.
Okay. So will the company then plan to, well, we have the, so we'll just need a refiling of that, right? Or is, because the public is redacted.
Correct.
Yeah, okay. All right. Okay. Anything else?
And then, Your Honor, for Ms. Keller, we had one housekeeping matter with reference to your new exhibit. You had requested a delayed exhibit, what will now be 4. And our note on that is simply that item does not exist yet. It won't come out until about October 15th. So as long as you are all right with us submitting that after the filing deadline for post-hearing exhibits, we can comply with that request.
Okay, and you'll have to refresh my memory. What was my, what was I asking for? I don't see it here on my list anymore.
It's right above the yellow highlight.
Oh, okay. S&P, oh, it's cited, but it doesn't exist? Or are we talking about different things?
It's cited as ordered. and we don't know the date yet.
I'm just confused. Can I use the public version? Will that work? Okay, can you just explain that a little bit? How does that, it's a market prices on, oh, it's emission allowances based on November 24th, 2021. And the report isn't out yet. Is that?
Oh, you were asking for what we used in the as filed? Not what's going to be in the final order?
Well, I guess I was just looking for a copy of the document you referenced. So let me put that up on the screen. So beginning of the passage starts on your page 10 of direct. It says, likewise, the footprint emission allowances were updated based on the November 24th, 2021 market allowances provided by S&P Global. There's a footnote 6. And then the footnote reads, this report incorporates the impact of the EPA's CSAPR update rule. And
Your question referred to footnote 7. I guess that was my,
oh,
I misunderstood that you were asking about footnote 6.
okay.
Sorry.
No, it's just a typo. I apologize. So yes, I think I think the updates from NYMEX will be included in our typical, update process. But
Right.
in terms of this S&P report, that's what I was.
Okay. Yes, we can provide that.
Great. Thanks. And thanks for seeking clarification of that. I appreciate.
With that, Ms. Keller is available for your honors questions or for cross.
Yeah, well, let's start with any cross.
Yeah, Your Honor, Stephanie Bedford for the Public Service Commission. We have cross-examination for witness Keller.
Go ahead.
Drawing your attention, Ms. Keller, to your sir rebuttal at page 3, lines 1 to 6. If you have that available.
I do.
Are you able to provide a specific dollar value for the capacity price for the months of September through December 2023?
The 10% of cone?
Yes. Are you able to provide a specific dollar value for that?
Yes.
Would you state that dollar value for me, please?
$24.16 a megawatt day.
Thank you. No further questions.
Okay, any other cross? Right. So did I get rid of your testimony? No, here it is. So just in terms of my clarifications, first of all, we can do this. Go back to page 11. Of your direct, and I guess, well, maybe more page, the bottom of page 10. Okay, I guess I just wanted to confirm with you that if we're going back to that footnote 6, the Casper update rule, that's a rule that's currently in effect. Is that correct?
Correct?
Okay, so we're not talking about any new proposals from the EPA.
No, the new proposal, there's no final decision and the allowance allocation is not known.
Okay, that's what I wanted to hear. Okay, all right, so then turning to page 14, I just wanted you to define for the record FTR, that acronym.
It's the financial transmission right, which is a financial instrument entitling the holder to receive compensation for congestion costs.
Okay. All right, and then on rebuttal. Page 7, rebuttal. Let's hope I got the citation right. Expand the screen here. Okay, there we go. So the bottom of page 7 on your rebuttal, you do make reference to the labor strike, but potential labor strike, and how it might impact the 2023 test year. So I guess the first question I'd have is, are you referring to the labor, the possibility of a labor strike that occurred recently?
Yes, for the railroads?
Yes.
Yes.
And can you just update us as to the status of that potential strike?
The contract ratification is still in process, so nothing has officially changed yet.
Okay. And is the strike still pending?
They have 60 days to ratify that contract.
Okay, it hasn't. I thought I read that it had been ratified. That's not the case.
No, not yet.
Okay, all right. Okay, and then so that's good. That's all. That's all we have. All right, great. That's all I have for you. Any redirect?
No, Your Honor. Thank you.
Okay. Thanks very much. You're excused.
Sorry, Your Honor, we have musical chairs again.
Fine. Who are we calling next?
Your Honor, we're going to call Bill Korducky as our next witness.
Okay, ready to go? I can swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right, go ahead.
Can you please state and spell your name for the record?
My name is William J. Korducky, Korducki.
All right, Bill, did you prepare a cause to be prepared, direct and rebuttal testimony for this case?
Yes, I did.
And Your Honor, we filed errata yesterday for Mr. Kordecki.
I see.
By that, yep. If I asked you the questions contained within your testimony, would your answers be the same today?
Yes.
And do you have any additional corrections to that testimony?
No.
No additions? I thought, Your Honor, can we just go off the record for a second?
Yeah, off the record, that's fine.
Not the testimony, the exhibit.
Oh, my apologies. We can go back to the record.
Yeah, okay, let's get back on.
Mr. Kordecki, did you also prepare a cause to be prepared 7 exhibits to your testimony?
Yes.
And then, Your Honor, we have one additional exhibit, an exhibit 8 that we will be filing by the deadline. So again, so that will get added to Mr. Kordecki's list of exhibits.
Yes.
Are your exhibits true and correct to the best of your knowledge?
You know, I have one correction yet to.
Okay.
And the correction is to exhibit WPSC-Kordecki 3. It's Schedule 1, page 2. And on page 2, for the CG-open paren FL, comma, IL, close paren, under both 2023 proposed rates and 2022 rates for firm sales, change the enhanced telemetry charge from $0 to 0.1973. And for the firm seasonal sales, change the enhanced telemetry charge from 0 to 0.3946.
So we'll be expecting a revised Kordecki 3.
Yes.
Yes, Your Honor.
While we're at this, let me just ask, has that change been served on parties and staff?
No, Your Honor, it's not. He just, Mr. Kordecki just found it last night, so I
Okay,
just wanted to add it to his list of corrections to his exhibit. My apologies.
okay. And just a general question in terms of the errata, and none of that's confidential, right? That's been
Correct.
held publicly. So to me, it looks like a lot of change, a lot of changes, and like the numbers really change a lot, but that could just be my inexpertise about all of this. But does this change the substance of the company's proposal, or are these just, corrections that people were expecting?
These are just corrections that would be expected. There was no oversight on my part with respect to the enhanced telemetry not appearing on one schedule.
Okay, so just conforming the schedule to the rest of what's been filed in the case.
Correct.
Okay, and that applies to so the telemetry applies to which changes? Just exhibit 3?
The ones listed on the errata. So
All of them, okay. They're all related to telemetry, is that right?
yes.
Okay, all right. Okay. Anything else you need to review?
No, Your Honor, that's all we had.
Okay. And any questions for the witness? Any cross? Didn't have any listed so far. And in terms of and we're okay with all the exhibit changes, with the refiling of the highlighted text, or whether we need. I guess the idea is if you need to keep those highlights in, just explain what they're for. If not, just file them without the highlights.
Yes, Your Honor, we were just going to refile them without.
Okay, all right. Okay, great. So there's no cross, no questions for me. I think we're done. Thanks very much. You're excused.
Thank you.
Okay.
Next, we're going to call Mr. Pecorelli.
Who is that? I'm sorry, I didn't hear you.
All right, Jared Pecorelli.
Right. See you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
All right, can you please state and spell your name for the record?
Jared J. Pecorelli, Peccarelli.
Did you prepare or cause to be prepared direct and rebuttal testimony in this case?
Yes, I did.
And if I asked you the questions contained in your testimony, would your answers be the same?
Yes, they would.
Do you have any corrections to your testimony?
Yes, I have one correction. In my rebuttal testimony on page 6, line 5, there is a reference to PSCW-RR-5. That reference is incorrect. The correct reference is PSCW-RR-19.
Let's just go off the record for a second. Just give me that page number one more time.
Or page 6.
A lot of COVID. I'm searching for -19 and it's not getting, not getting me very far because you put COVID-19 in a lot of places. Okay, so let's just, can we just make sure that that is not a data request that'll be included in staff's exhibit? And I thought when you mentioned 5, that was 40, so I don't know. I probably want to put that in the record because you're relying on its description. So let's just get on the record. So we were just discussing the reference that witness Piccarelli had made to PSC staff data request. And just give me the new number again.
Sure, it's RR19.
19, right. So I think because it's being relied upon in testimony, let's have the company file that as Piccarelli 4. Is that okay?
Sure, Your Honor.
Okay. All right. Okay, anything else?
Yes, Your Honor. Mr. Peccarelli also has a couple of 2 exhibits that he prepared a cause to be prepared. Mr. Peccarelli, did you also prepare a cause to be prepared 2 exhibits?
Yes.
And are those true and correct to the best of your knowledge?
Yes, they are.
All right, Your Honor. Other than, I think, the questions that you have for Mr. Peccarelli, that's all we had on our end.
All right. So just checking any cross at this point. Oh, okay. All right, yeah, so let's turn to your direct quickly here. So page 4, you mentioned some of the impacts in the sales forecast related to the loss of some pretty large customers, it sounds like. So it was, you referenced
And Your Honor, while you're looking for that, I just want to state that the identities of those customers is confidential. So if we were to name those individual entities, we'd have to go into closed session.
I figured that was probably the case. I don't think the name is necessary. I just was curious more to the fact of losing the 3 customers, if there's a reason for that. That's not, that doesn't need to be, you know, identifying identity of those companies, but oh, that's why. Okay, so yeah, so generally speaking, I think it's really a cross between Piccarelli 4 and 5. Just discusses the large decrease in forecasted sales due to fewer wholesale customers, and it cites 2 contracts ending at the end of 2020 and one ending in June 2021. And I was just, oh, and then another one, double N. Okay, as on 2023, but I guess we still have that customer. So I'm just curious if there's any reason why the company lost those wholesale service contracts.
I'm not aware of any specific reason aside from that these were the termination dates of long-term contracts for the 4 customers cited.
So would it be fair to say they refused to continue those contracts, or?
I was not a direct participant in any discussions between the company or these customers.
Okay, all right, that's fine. And then the other question related to the interruptible electrical generation class, that's Piccarelli 6.
Yeah, Your Honor, again, I think if we're going to identify the interruptible customers, we'd have to go into closed session. And I'm not sure how to answer this question without going into closed session.
Okay. Well, that's fine. I don't know. It just wanted to complete the record. I don't know if it's really that in yeah, well, let's do that just to get the record clear. I want to make sure it's complete. So so let's briefly go into closed. So I'm just going to I'm going to create a waiting room for so we do this a little differently now that we have YouTube. We're going to put everyone in a Zoom room and let the YouTube stream continue on without any input to it. So I'm going to.
And Your Honor, this is Kurt Bain for Roundy's. I'm not sure if I signed the agreement for this case.
Okay, and that's
and I actually don't have any cross today. So if I could be excused from the remainder of the hearing, that would be appreciated.
So where are you now? Yeah, that's up to you. I'll let it's your prerogative. If you want to leave the hearing, that's fine.
Thank you.
All right.
Your Honor, similarly, this is Barry Naum for Walmart. Walmart was a late intervener in this case, and I cannot recall if we have executed an agreement. I don't know if the company can confirm, but we would need to be excluded to the extent that we have not signed that agreement.
Okay. So what I'm going to do, I'm going to create this room, and then whoever is authorized to hear that testimony should join the room. Whoever's not should not be in the room. So you have that option to join or not. And once we have people in the room, we can decide whether we have the right people. So let me get the room up and going first. So you'll just need to join that room. I don't, so Mon, are you there? Oh, yeah, I think people are joining now. Yeah. Is that right?
Yes, I am here.
Okay, good. So it looks like people are joining, right? Can you see that? Yeah, they're joined. Okay.
Yep.
Asking, do I have to join the room or am I?
Yes, you would have to go to that room and leave this one.
See that? It's not asking me. Where would I find?
Click breakout rooms, and then next to room 1, you should have a join button.
No.
Do you see the button?
No, it's showing me the room itself where that I created, but it's not asking me to join. Oh, wait, is it? Oh, maybe that's it. Okay, yes.
Judge, you're on mute.
That's okay. I was just talking to myself anyway. Spared you that much. Great. All right, readjusted here. Okay, so I think that's all the questions we have for witness Piccarelli. Is that true? Yep. All right, great. You're excused. Thanks very much. Oh, you're on, company's on mute. I guess everyone gets on, is muted. I don't know why.
Can you hear me now, Your Honor?
Yeah, go ahead.
Sorry. You did have one more question for Mr. Piccarelli.
Did I? Okay. Oh, yes, you're right. Oh, yeah, good one. Okay. Sorry about that. All right, let's get to that. So there did have a question on rebuttal, and it dealt with the Google mobility report data. And it doesn't look like anyone else had a problem with that. But I wasn't sure what I was looking at exactly, so I wanted to understand it a little more. So it's rebuttal pages 3 through 5. And I think, we understand what it is, but I'm just curious. I guess I wasn't sure. How we know it's accurate is really the first question I'm wondering about, and if there's any foundation about your involvement in using this application, I guess, and how. And there's another issue, doing some research into it. I see that there was calibrations that had to be set before a report could be generated. So I wasn't sure if you knew what your calibrations were. I guess if you could just give me a little information, a little bit of background about this information, just to make me feel a little more comfortable about receiving it on the record, that would be appreciated.
Sure, Your Honor. As background, this data was being presented. It's not in support of the sales forecast directly. It wasn't used in generation of the sales forecast. Rather, it was to rebut staff's contention that the electric residential average use per customer the company experienced in 2021 was not being, let's say, unduly influenced by the pandemic, by the shift in many individuals working from home, schools being maybe closed, things of that nature. So that's the background for trying to acquire some independent data that would help to support what the companies was seeing and what we were proposing in the sales forecast. That's a little background of it. As far as you mentioned the calibration, I believe you're referring to, there's like a 5-step process that Google lays out that one could go through to quote unquote calibrate the reports. The company did not specifically take those steps. In most cases, I would say that those are steps one would take if someone was concerned that it would be inaccurate to assume that 100% of the change in trends that someone was seeing in the reports was attributable to the pandemic. I think it's reasonable to conclude that at least most of the change in the trends that the reports are showing, in this case for Brown County, would be attributable to COVID without quote unquote calibrating for things like weather or individual usage patterns of different types of workers. And then as the chart shows that you have up on the screen from my rebuttal testimony, there were really, I would say, two, not calibration steps, but two steps the company took to kind of validate the data at a higher level. One is the data was smoothed out. It's daily data, the raw data. And so it was a 7-day moving average was applied to smooth out the volatility between weekdays and weekends. And then you'll note the annotations on the chart are showing that the pattern we're seeing in this case with the change in the duration of mobile devices, individuals at their residence, it very closely mirrors the various waves that were experienced of the pandemic. So that speaks, I believe, a little bit to your question about the potential accuracy of the data, at least at a very high level.
Okay, and do you know of any independent study that verified this Google mobility report as being accurate in general?
I can say that Itron, the company Itron, they have presented this data to their customers that utilize their utility customers that utilize their sales forecasting products, and presented use of this data as being a great way to try to capture the dynamic impacts of COVID throughout the pandemic. And they made a presentation to their customers, and they also published on their blog in 2021 information describing these Google Community Mobility Reports in detail and how to incorporate them in the sales forecasting process.
Okay, all right. Any questions for this witness on that topic? No. All right, we'll leave it at that then. Okay, great. Well, thanks for catching that as well. But yes, thanks for the answer on that. And any follow-up redirect?
No, Your Honor.
All right, great. All right, excellent. Thanks very much. You're excused.
All right, James Goldschmidt again for the court reporter,
Thank you.
and the company will call Joe Zagans.
I'm sorry, is it Joe? Joel.
Joe,
Okay, thanks. All right. Oh, great. Where are you? There you are. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Thanks. Go ahead.
please state and spell your name for the record.
Joseph L. Zagans. Last name is Z-G-O-N-C.
Thank you. Mr. Zagans, did you prepare or cause to be prepared and filed direct and rebuttal testimony in this case?
Yes.
And did you also prepare or cause to be prepared and filed 11 exhibits supporting your testimony?
Yes.
To the best of your knowledge, were your testimony and exhibits true and correct as of their filing?
Yes.
Do you have any changes or corrections you wish to make to your testimony or exhibits?
No, I do not.
All right, Your Honor, Mr. Zagans is available for cross.
All right. Okay, and are we okay with the exhibit refiling and corrections to testimony? That's all understood?
Yes, we'll get that taken care of.
Okay, great. Okay, so the question on staffing plan, I'm going to forego. I think we got enough on that already. Anyone else have cross this time? No? All right. Thanks very much. I think that's it, right? You're excused.
Okay, thank you.
Thank you.
Who's next?
Good morning, Brad Jackson, appearing, and our next witness is Ann Bulkley.
All right, a name I can spell. Let's get started. Where are you? There you are. Let's see. I'm having a little. Can you turn the camera a little bit closer? There we go. Perfect. Thank you. All right. Let me swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
Okay. Go ahead.
Ms. Bulkley, will you please state and spell your name for the record, please?
Yes, it's Ann Bulkley, B as in boy, Ulkley.
And by whom are you employed?
The Brattle Group.
I'm sorry.
The Brattle Group,
you.
Brattle.
Ms. Bulkley, in connection with this proceeding, did you prepare or have prepared at your direction pre-filed written direct rebuttal, surrebuttal, and surrebuttal testimony?
Yes, I did.
And in connection with that testimony, did you also prepare or have prepared at your direction 18 exhibits?
Yes, I did.
Were I to ask you the questions contained in your pre-filed testimony, would your answers be the same?
Yes, they would.
And do you have any corrections to any parts of your testimony or any of your exhibits?
No, I do not.
Thank you. Your Honor, the witness is available to cross. I noted that you asked for 3 additional exhibits from her. You're free to talk to her about those, or I could, whatever your druthers are.
Okay. Well, let me just ask you, Witness Bulkley, do you understand the exhibits I'm asking you to create? Any questions? Have I confused you?
I do understand, Your Honor. I understand the first 2 exhibits. The 3rd exhibit is requesting information. It asks for information, a price chart indicating where I claim a price to have changed for the specific cases I describe in my testimony. In my rebuttal testimony, I have only testified that there was to 1 price change, which was shown in the figure that you identify. The remaining cases that you've identified and requested regulatory decisions on in the 2nd exhibit, my testimony is that the credit rating agencies had downgraded those companies. So I'm not exactly sure how I would prepare the exhibit you're requesting for the 3rd exhibit.
Okay. So for companies 2 through 4, on my comment, you the prices, was there a correlation between the order reducing the ROE in those companies and the price per share?
Well, it's my testimony that the credit rating agencies downgraded those entities, not necessarily that there was a change in the price for those companies. Some of them are not. Each of those are subsidiaries of a larger entity, and I did not testify to a price change there.
Okay, I see what you're saying. Okay, well then I guess we'll just change the intent there that I was meaning. I think if we could have the same chart created for each, but just to simply show the date at which the order reducing the ROE occurred on the chart, that's relevant to your testimony, and regardless of whether you're claiming the share price went down or not, because of that order, just the date of the order, along in the chart, as well as the 2 the 2 lines of information, the price and the market trend.
Okay. So I just want to make sure I clarify, because I'm not sure that that's going to identify what you are hoping to achieve, because in each of these jurisdictions, there would have been a public meeting where the commissions identified their decisions ahead of time. And so the order would follow for some time period after. And so I'm not certain that that will actually identify the time event study that you're looking to see. Does that make sense?
Yeah, I understand. Well, that's an interesting point. So why don't we put both dates, if you have the date of the open meeting, the decision date, and the date the order was issued, we put both of those dates into the chart. There may be some reason why the market would respond to an open meeting versus responding to an actual official decision. So
Sure.
Yeah, that may be useful to have both.
Okay.
All right. Any other questions about that?
No, I don't believe so.
Okay. And the timing, we usually expect these filings to be turned in 3 business days after the hearing. Will that give you enough time?
Yes, I believe that will.
Okay. All right. All right, great. So did we have any? Well, I think we have crossed for you. I hope everyone's prepared. Just to clean up the other questions I had.
Yeah.
Yeah, go ahead.
Get some general questions at the end that I think Ms. Bulkley would be our witness to respond to.
Oh, yes, those two. Okay. All right. Well, just some cleanup before we continue. So I just was wondering, you did file exhibits 7 through 10 confidentially, and just looking at what was appearing confidentially, it didn't look like it met the standard requirements for, whether that is like create a competitive advantage or harm the utility, our typical standards for keeping information confidential. And I wondered what was the basis for you to claim that information is confidential.
Yes, Your Honor, I'd be happy to answer that. The data that was provided in those exhibits is obtained through the Standard & Poor's Capital IQ Pro license that the Brattle Group has. And as part of the terms associated with that license, Standard & Poor's requires that we keep this information confidential. It is their view that the aggregation of the data with respect to Exhibit 7 is their work product and has value, and so they have requested that that information be kept confidential. The other 2 exhibits are derived from Standard & Poor's analysis about each of the regulatory jurisdictions, and they require that those documents be kept confidential because it's a saleable item. Okay.
And so just so everyone knows, that I could be wrong now, my memory may not be serving me correctly, but I believe I checked the applications for confidentiality status, and I don't think that was explained in there. So if those explanations are given in the request, they would just avoid having to review it at this time. So just wanted to make that clear for everybody. So that's fine. I just wanted some clarity on those. And so how does council wish to proceed? Are we ready for the general questions, or do you have anything else you want to do before that?
No, we're ready for the general questions. And it would be 1B and number 2. 1B and number 2.
Okay, excellent, thanks. Okay, great. So witness Bulkey, so I'm asking these questions to the most appropriate witness for each party, for each participant. So let me, and council's directed me to ask these of you. So let's proceed. So to the extent that Wisconsin Public Service has a preference for the following, state it and cite to where it appears in the record. And for you, asking that in terms of cost of equity and return on equity.
Yes, Your Honor. So I have relied on these terms fairly interchangeably throughout my testimony without a specific preference. I do recognize that the models can often are often referred to as cost of equity models. I do understand the distinction between cost of equity and return on equity that that is being made here. However, I have used them interchangeably. And I think that's been customary in many jurisdictions. So I didn't mean to create some confusion there.
Okay, and I guess what I was curious about is at what level of cost of equity or return on equity return on equity is the company's preferred version of those of the return on equity? What's your number at this point in time?
Yes, I'm recommending the 10% return on equity.
Okay,
I'm sorry, I thought you were looking for the distinction that's been made in pages of testimony here on COE versus ROE. I misinterpreted the question.
Your answer was quite a good one, so I appreciate that. But I'm also looking just for the company's current number, and you said it's 10% at this point. And I know that does appear in a number of places on the record, so we will leave it there. Great. Okay, I think that's all I have for you on that, and we can pursue cross-examination. Yeah.
I think you had a second question there as well, number 2.
Oh, was that for her too? Yeah, you're right.
Yes, please.
Thank you. Yes. Okay. So that's question 2. Yes. If the commission approved a return on equity for Wisconsin Public Service Corporation below 10%, how would the credit rating agency's descriptions of the regulatory environment in Wisconsin change?
Yes, this is a good question. I have provided a fair amount of information in my testimony about how regulatory decisions are viewed by the credit rating agencies. And it is the subject of some of the additional exhibits that you've asked for in my testimony. I believe that the credit rating agencies would view that negatively, and I would like to sort of expand on why. When looking at the examples that I've provided in my testimony, it's important to note that many of these were in the range of between 9 and 10% at times when interest rates were considerably lower than they are today. So if you were to look at the CL&P case, APS, and Centerpoint, each of those decisions was ordered at a time when the interest rates were at about 2%. The Elite case was at about 2.94%. Yesterday's close, the 30-year, these are all 30-year Treasury bond yields. Yesterday's close, the 30-year Treasury bond yield was at 3.66%. So we're looking at a much higher interest rate environment. Obviously, those particular examples that I've provided were viewed negatively by the credit rating agencies at that time. So I believe that in a higher interest rate environment, that would also be the case.
So your terminology that you would think credit rating agencies would describe the regulatory environment as negative.
Well, I think they would view this as a negative determination.
Okay, but in terms of like the term of art that they would use in their report, would that be the word that they would put in their report, in a negative regulatory environment?
Well, I think they would, yes, I think the decision itself would be viewed negatively. Yes, I think that's true.
Okay, because they usually have like there's a scale of credit ratings like A and AA, and there also seems to be like a scale of regulatory environment. And they use the terms in some sort of that way. Where does that make sense to you?
I don't think they have a specific scale for how they review regulating. That's why I hesitate to use a scale to describe it, but I do think that the decision would be viewed negatively. Yes, okay. I don't necessarily know that I can place a specific, they don't have, it's not like the outlook, which is stable, or, there's not a scale like the outlook that I am aware of for the rating agencies to assign. But I would say that the decision would be viewed negatively.
Okay, all right. Thanks for clarifying. That's good. Okay, great. So any follow-up on that question?
No, Your Honor.
All right. So is the witness available for cross?
Yes, she is.
All right. So let's begin. We can start with our first party on the list, which is Clean Wisconsin.
Your Honor, if I may,
Yes.
would it be possible for those parties where no other parties indicated cross, such as Renew, to get our witnesses out of the way before some of the other parties?
That would be possible, yes, but we'll have to wait till after this witness.
Does have some cross for Ms. Bulkley.
Okay, just wondering about Clean.
Don't have any questions for Ms. Bulkley.
Okay, go ahead. Okay, so Cub, let's have you start. Attorney Copeland Ferris.
Good afternoon, Ms. Bulkley.
Good afternoon.
I'm Kara Copeland Ferris with the Citizens Utility Board of Wisconsin. Do you have your rebuttal testimony in front of you?
Yes, I do.
Would you please turn to page 41? And my questions refer back to some of the questions that Judge Newmark posed to you. So in this section from page 41 to 45, you present examples of these 4 utilities that you describe as having sustained negative outcomes due to relatively low authorized ROEs. Is that a correct characterization of this section of your testimony?
Yes, they do include. Actually, can you state that one more time? Your microphone is a little bit hard to hear. It's a little bit muffled, so I just want to make sure I have your question clearly.
Sure, I apologize. Is this better?
A little bit.
Can you
Okay.
let us know where you are exactly? I didn't get the reference.
I'm on page 41 of her rebuttal testimony.
Thank you.
At the bottom of the page. And going on to page 45, these are examples of utilities that you describe as having sustained negative outcomes due to relatively low authorized ROEs. Is that a correct characterization of your testimony in this section?
Yes, it is a description of those cases where utilities sustained negative rating action or market activity related to rate case decisions.
Okay. Ms. Bulkley, do you have any quantitative evidence of that the reduction in ROE for Connecticut Light and Power has impaired the company's ability to attract capital?
No, I don't necessarily know that they have actually sought capital. So I will say that in the Pinnacle West case, I think this is in my Sir rebuttal testimony, it was noted by the, in the 2021 annual report that they had deferred equity issuances as a result of this, of their outcome. I don't necessarily know for some CL&P.
Okay, and was that deferral in APS, would you characterize that as an impairment in the company's ability to attract capital?
It was an inability from their perspective to attract equity capital on reasonable terms, I believe. If you were to look at my rebuttal testimony, I think my Sir rebuttal, excuse me, testimony, I identified the in the 2021 annual report, the letter to shareholders and the discussion in that letter, electing not to issue equity until their next rate determination.
So, so in your view, that has that demonstrates an impairment in the company's ability to attract capital.
Yes, I do think that's makes it more difficult to attract capital, yes.
But is
So
that
recognition.
quantitative evidence that the company now has an impaired ability to attract capital?
I think that's a demonstration that the company feels they cannot attract equity capital on reasonable terms because they are deferring any equity capital issuances until their next rate proceeding.
And could you describe what you mean by reasonable terms?
Well, I think they're considering the overall cost associated with that, probably. I would say that the statement, I think, speaks for itself in the 2021 annual report. As I noted in my Sir rebuttal testimony, that they had committed to protect shareholders as much as possible by deferring equity needs until 2024, defending the dividend and managing their capital program to ensure that they maintain investment grade credit ratings. So I think the outcome of that case put them at risk with respect to attracting equity capital, and to the extent that their credit ratings were of concern, it would also affect the ability to access the debt markets.
Okay, so do you have any quantitative manifestation of that risk that you describe for any of these four utilities that you cite in this section of your rebuttal testimony?
Well, I'm citing to the example right here of a case where the company has deferred its access to the market for capital. I'm not sure what you mean by quantitative. This is an observable incident where the company has said, we will not access the capital markets because we need to maintain our credit ratings and we need to protect our existing shareholders. So we can't access the capital markets. I don't know how to quantify that for you more, but that's a reasonable example.
Okay, so for example, have you reviewed the cash flow statements of Arizona Public Service subsequent to the cited ROE reduction?
No, I have not.
Okay.
I have relied on actually the same letter to shareholders that Dr. Keim relied on to suggest that nothing had changed for the company. So I'm relying on the exact same document that Dr. Keim relied on in my Sir rebuttal testimony here.
Okay. Okay. Ms. Bulkley, do you have any examples in the past few decades of an authorized ROE reduction impairing a utility's ability to attract capital?
I just described it right here.
Aside from this cited example with Arizona Public Service?
This is the most recent example. I don't have a running list for you. No, this is the most recent example I was able to provide. I think it's relevant in this circumstance, given that it's, 2021 and 2022, it's current. So I don't have a database of examples to offer you now.
Does any example come to mind that we could refer to?
The example that we've been discussing. I don't really have a list in my mind, no.
Sorry, my question wasn't clear. Do any historic examples come to mind, something within the past 10 to 20 years?
I don't have a list in my mind of that. I did not prepare a list for this proceeding.
Okay, thank you. So returning to a different topic somewhat, you mentioned today your use of cost of equity and return on equity interchangeably. And you also make this clear in a footnote on page 3 of your rebuttal testimony. And I just have one question related to that interchangeable use of these two terms. So are we then to understand that you believe that cost of equity and return on equity are interchangeable?
What I think is important to recognize is that the data that's used in the models is market data. So does it reflect the cost of equity? Yes, it does, properly specified. I believe that my models represent the cost of equity, which is used by a regulatory commission in establishing the return on equity. So while my testimony may not have specifically identified the models as cost of equity models, they are all using market data that reflect the investor required return based on current market data. And it should be used to establish the return on equity by a regulator. This is something that only in a few jurisdictions is this particular clarification required. I would say I have testified in more than at least 100 cases on return on equity, and I have never seen so many pages devoted to this issue because it is usually an accepted principle that is known that what we're doing, the purpose is to set the ROE based on using models with market data from the COE.
Okay. Forgive my confusion. So if we were to substitute cost of equity for ROE or the other way around in your testimony, would that change the meaning?
As I said, I think that I have used them interchangeably, recognizing that there are differences. I think there are certain places where the ROE might be the right term and certain places where the COE may be the more theoretically correct term. The analysis that's been prepared has been prepared based on the market information and is reasonable to be relied upon by the commission to establish the ROE. You would need to go line by line is the answer to your question.
To understand whether you mean ROE or cost of equity?
I would say as a general
one or the other use of those terms.
Yes, I would say as
I'm
a
sorry,
general
excuse me.
characterization.
Excuse me. I didn't get the end of the question because you were both talking. To understand whether you mean ROE or cost of equity?
Given use of one or the other term.
Thank you.
I would say as a general proposition, the references to the models would reflect the cost of equity. And the reference to the decided return would be an ROE.
Okay, so is your testimony then that, is your testimony then that when you say cost of equity, you mean one thing, and when you say return on equity in your testimony, you mean another?
I think I've just described the example and how you would need to refer to that. When we're referring to the models and the investor requirements, I would say they should be technically the cost of equity, and the determination by a regulatory commission is a return on equity.
Okay. Thank you, Ms. Bulkley. No further questions.
Okay. Who else has cross for this witness? Well, that's a surprise. Okay, so I did have one follow-up that I'd forgotten to ask. Appreciate your patience here. And I was just curious, I did review a bit of the Arizona Public Service Companies, the order that the Arizona Corporation Commission issued that's been addressed in testimony. And I did note that Witness Bulkey was involved in that case. Is that correct?
That's correct.
Okay. So I also saw online that the Arizona Public Service Company has petitioned for review of the Corporation Commission's order. And I was wondering if you're familiar with the case that Arizona Public Service Company is making.
What their review is based on, the legal basis for their review, is that what you're asking?
Well, I'm just interested if you know of that that appeal of the case?
Oh, I do know that it exists. Yes, I do
Okay.
know that they are appealing it. I'm sorry. I thought you were asking me for the basis for the appeal.
No, that's not what I'm asking. Do you know what they're contesting in terms of the level of ROE that was set in that case?
The ROE that was set in the case was 8.7. Is that what your question is? What was the return in the decision? Is that what your question is?
What is the company appealing?
They are appealing the 8.7% ROE.
How much of that percentage, do you know?
I would have to look at that appeal more closely. I can't answer that.
Okay.
I'm happy, if you have it, I'm happy to take a look at it with you. I just don't know it off the top of my head.
Yeah, I understand. So it looks like, my understanding, I'm reading the petition. I can put that on the screen. So that's the document that we'll be introducing as an exhibit. So it's my understanding that the company is contesting the 20 basis point reduction that the commission adopted when it reduced the 8.9% ROE to 8.7%. Does that sound familiar to you?
That is a penalty that they were assessed. I don't actually know. No, I don't. I can't answer that.
You don't have any information behind that.
I'm sorry, I can't answer that. Yeah, I don't know.
That's fine. Just wanted to know. So that'll be so that petition is going to be an exhibit and people can review it. I just want to know if you had any personal information about the facts there. So that's fine. All right. So no other cross? How about redirect?
Judge, this is Commissioner Huebner. I just have a really quick question based on that case.
Yes.
Hi, Ms. Bulkley. I'm Commissioner Tyler Huebner. My question related to that case is, what was the ROE that had been in place before the Arizona Commission's decision to change it to 8.7%? Do you know that?
I can pull it for you. I don't know it. Something I can provide to you, though, off the top of my head, I don't recall it. Let me.
It's I'm sure it will be. It does appear in the order that will be made part of the record, and that's a document I'm going to be offering or uploading to IRF. That's going to be titled EXPSC ACC decision. And that's just the version of it from Westlaw. And it's about 1,000 pages about this case. You think our cases are long. And I'm sure the number is going to be in there. I know that part of the history of this case is that the ALJ issued a proposed decision. I think it recommended a 9 point, somewhere in the middle of a 9.6, 9.5% ROE. And then when the commission reviewed that order, they dropped it to 8.9, and then they attached this penalty provision of 20 basis points so that the final order was 8.7%.
The recommended, in my testimony, the recommended opinion and order, which was issued in August 2021, was 916, and that is shown on figure 9 of my rebuttal testimony. That's when the sort of first drop occurred in their stock price, and then the second drop was at the 8.7. So, but I don't recall.
I'm sorry, the second drop was at?
I'm sorry, 8.7.
Thank you.
But I don't recall the return on equity that the company had prior to that case, which is what your question is, I believe, Commissioner. And that's something that I'd be happy to provide. I just don't have it.
Okay, thank you.
All right, so any other cross-examination? No, how about redirect?
Mike, it's Becky.
Oh, go ahead.
Hi, Ms. Bulkley. I'm Becky Vock. I'm the chairperson of the Wisconsin Commission. Can I just bring you back to the line of questioning that the attorney for Cub, Ms. Ferris, was asking you along the lines of the impact of a reduction in ROE? And I was having a little difficult time hearing. So I believe the two of you were having a discussion about a decrease in ROE, which then led the utility to sort of press pause on going out to the market to seek capital. Do you recall that conversation?
Yes, I do. That was in the Pinnacle West case. That's the case that we were referring to there in that testimony.
And what's the vintage of that case?
This case was 2021, essentially. So the case occurred over an extended time period, but the decisions were in 2021. The first decision was in August of 2021, which was this recommended decision we were just discussing. And the second was in, I believe, November of 2021. Although I think the actual commission deliberations were back in October, and that's what's shown in my chart.
Okay.
And then the letter to shareholders was in the 2021 annual report to shareholders, indicating that they would not be seeking capital because they wanted to maintain equity capital, because they needed to maintain their investment grade ratings and protect shareholders.
Okay.
So that would have all been very recent.
Okay. So has there been any update since that letter to shareholders?
No, they, to my knowledge, have not filed a case. It looked like they were deferring any equity needs until 2024. That's what was specified in their 2021 letter to shareholders, so that they would not be issuing equity for an extended, for a couple of years in order to maintain their credit ratings and to protect shareholders.
Okay. And was there any other reason, either in the letter or based on your expert opinion, any other reason given besides the decision from the commission?
No, I mean, the specific quote that's in my Sir rebuttal says, while 2021 finished strong, we have guided expectations for 2022 as a financial reset year due to unfavorable outcomes of our recent rate case. We have also committed to protect shareholders as much as possible by deferring equity needs until 2024, defending the dividend, and managing our capital program to ensure that we maintain investment grade ratings. So to me, that was very clear that it was as an outcome of that rate case, and that they would be managing capital and conserving capital until their next case.
Okay. Okay. And just for clarification, that wasn't a single issue rate case, correct? It was
not. It was a full rate case.
Okay, great. That's helpful. Thank you for allowing me to ask the question.
Oh, absolutely. So that did jog my memory on another question. I apologize. But the Arizona Corporation Commission's decision had made other adjustments to the Arizona Public Service Corporation's revenue requirement that was detrimental to the company, or I guess negative to the company. There was one significant one. Do you know what I'm talking about?
The case had a lot of twists in it. So there were a lot of issues. Certainly the ROE was a very significant value driver in that revenue requirement change. Yes, there were some other things in the case that was not, by itself, but it was a significant value driver.
How about that SCR the decision to disallow recovery for SCR investments?
Yes, that was the other driver of the case. That's
Do you know how much money that was involved?
I don't actually know that. I don't have that.
We don't have to. I don't have to stress your memory here, but I can. The order will be in the record, so all that information is going to be available for the commission. But it is true that there's more issues to the case than simply the ROE. I can provide some information to Commissioner Huebner's question. So I'm going to just display. I think it's page 41, the Westlaw page for the ACC decision, and it discusses the most recent APS rate case, which was decided in June 28th, 2007. And the next page describes that it was a settled case, and the settlement allowed return on common equity of 10%. So that I believe is the previous ROE that was in play before the commission when the ACC made its decision. But again, the order will be in the record, and it speaks for itself, and anyone can rely on that to get more background and context to the APS issue. So, anything else? Anybody? All right. So, is it time for redirect?
I hope so.
Where are you? There you are. Excellent. Okay, go ahead. Attorney Jackson.
Thank you. Ms. Bulkley, to stay on topic for just a moment. So we've heard that in addition to the reduced ROE, there was also a reduction in the company's request for recovery of SCR capital costs. Is that your understanding?
Yes.
The APS case. Now, that would result, would it not, in a reduction in the utility's rate base on which it earns going forward, correct?
Yes, it would.
And the lower ROE would reduce the company's earnings on that lower rate base, correct?
Yes, that is also true.
And how do those two relate to each other? How do they impact each other, and what's the ultimate result?
The ultimate results would be that it would lower the overall cash flow for the company and would weaken its credit metrics.
Were you the ROE witness for APS in that case?
Yes, I was.
Do you recall what the utility was asking for in terms of an authorized return?
I believe it was in the range of 10-2.
Is that 10.2?
1.2.
Yes, it is.
Thank you.
Thank you. Going back to Ms. Ferris's questions regarding the utilities you described in your rebuttal at between pages 41 and 45. Just generally speaking, you talk on page 42 about CL&P receiving changed outlooks from Moody's and Fitch Ratings. Moody's changed its outlook to negative, and Fitch also revised its outlook to negative. Generally speaking, all of the things equal, does such a change on outlook by credit rating agencies of a utility from something more positive to quote unquote negative, would that tend to increase the utility's cost of debt if they were to issue debt?
It can, yes, and it's also typically a precursor to a full downgrade in the rating. So the negative outlook is sort of the first step to a downgrade in the company's overall rating.
And then on page 43 of your rebuttal, you note that in response to ROE decisions, the credit rating agencies actually downgraded Elite and Centerpoint. And I guess the same question, that would that downgrade, all other things equal, result in an increase in the utilities' cost of debt should they issue debt?
Yes, it would.
And that'd be the same for APS, which was also downgraded after the decision we've discussed, correct?
Yes, that's correct. And I would say that's probably why they are also managing their capital program at APS, because of the need to maintain the cash flow metrics and to maintain their credit ratings. So they will likely not be able to meet the original planned capital program based on what the 2021 annual report indicated.
And until those utilities actually issued debt, we would not have quantitative information on what the precise amount of the increase in cost would be, correct?
That's correct.
Objection, Your Honor. This line of questioning is leading.
Well, I'll allow it. It's fine. This is nothing that's not in the record or isn't common knowledge. So pursue this for a little while.
No, that's all I had, Your Honor. Thank you.
All right. I think that's all we have.
Judge,
So-
can I ask a follow-up?
yes, go ahead.
Okay, Ms. Bulkley, Mr. Jackson just asked you a line of questioning about the potential impact of a lower ROE. He took you from a lower RE leading to a negative outlook and then leading to ultimately a downgrade. So is it your testimony that if the commission were to issue an ROE lower than what the company has proposed, that would lead to an immediate finding of a negative outlook by the credit agencies?
So the credit agencies, I think, will take into consideration the fact that the cost of equity is actually increasing given where interest rates are. So if you were to look at my testimony on my rebuttal testimony on page 13, I have a figure that identifies where interest rates were when the company's last case was determined and sort of where we sit today, and have demonstrated about 100 basis points increase in interest rates since that time, and then bringing that current another 46 basis points. So we're up about 166 basis points from when the company had its last case. That's an important consideration in determining where the ROE should be going. If the ROE were, so that would be an expectation that the ROEs would be increasing because interest rates and return on equity for utilities have traditionally been correlated. And that's demonstrated in the bond yield risk premium analysis that I provided in my direct testimony. And I can find that exhibit. So I would expect that is exhibit, let me just finish that thought. That is exhibit 7C that demonstrates that correlation. And so the expectation is for interest rates to be increasing. There's a lot of testimony written about that in this case, and that the return on equity, the cost of equity would be increasing. So to have the ROE be lower directionally would be viewed negatively. The examples that I've provided in the pages that we've spent some time on here today demonstrate that the returns don't actually need to be that low to trigger that kind of a response. So the changes don't need to be that drastic. So for example, CenterPoint Energy Houston had a 9.4% ROE coming down from 10, and they were downgraded. So the recommendations of the Cub witness at 9 in this environment, where we're in a rising interest rate environment, would be a significant departure for sure. As I mentioned earlier, the CenterPoint Energy Houston case was decided when interest rates were at 2%. We're at 3.66. So we're in a much higher market, going to returns that are as low as are proposed by witnesses in this case, in this environment, would be viewed very negatively.
And thank you for that clarification. Can you just help me understand what's the timeline associated with, going from a negative outlook to ending in a position where a company is downgraded? Is it something that happens, instantaneously? Are you talking it happens the next quarter? Help me understand that.
Sure. There's not a perfect answer for that, to be honest, and it depends on the circumstance. So in the CLNP case, this is in my testimony, the outlook was changed in June, and they were downgraded, I believe, in September that year. Actually, let me just...
Where are you on your testimony?
Yep. So this is page 42 and 43.
In rebuttal.
My rebuttal testimony. So the decisions can happen fairly quickly. And there's not necessarily a requirement from the credit rating agencies to step through the process of a negative outlook to a downgrade. That's not necessarily a required individual step.
Okay, so they could skip right to downgrading.
They could.
Would it be helpful with the exhibit that I had asked for, the chart with the timing of share price? Would it be helpful to also indicate if a downgrade, a negative treatment, or a downgrade could also be indicated for those companies?
I would find it helpful.
Okay.
Yes, I think I've identified that. I can put it on the charts as well, but it's identified in my rebuttal testimony. For example, if you were to look at...
I understand that. I'm just curious, for the exhibit that I was requesting, would that included the other companies besides Arizona Public Service? If you could include and delineate where like we were saying, where the decision was rendered, where the order was issued, indicate that in terms of the timing on the chart, and then also indicate if there was any negative treatment announced and then any downgrade announced.
Sure.
Those dates, yeah,
Sure.
that may just give us a good graphic visual of all of those. And if you could include that, and that would include APS, because that's part of this as well.
Sure. Yeah, I think APS, I would just add that it was roughly a month following the final decision.
Okay.
So if I'm understanding this table, it would include, if it happened, that a change in outlook by the credit rating agency, and then if it happened, an actual downgrade of the credit rating. Right?
Yes, that's what I'm asking for you.
Okay.
In addition to the other, the decision in open meeting and the final order issuance. So it'd be four indicators along the x-axis, I guess, if you want to.
It's going to be a really depressing exhibit.
Okay, so, I I had one question based on an answer that you gave to Attorney Corbin Forrest, but are there any other questions? So I did want to follow up a little bit. I know you did mention that it's kind of surprising to see the distinction between cost of equity and return on equity being discussed in testimony. And you mentioned there are a few other jurisdictions where that comes up. I was just wondering, in your experience, which jurisdictions were those?
Only other jurisdiction that I know of where this is very specific is in Indiana, where it's very deliberately identified the cost of equity estimates versus the return on equity decision.
Okay. And any others where it comes up at all? I think you might have mentioned it happened a few times, but.
Yeah, it's possible. Illinois may be another jurisdiction, but I think it might be Illinois. It comes up very infrequently. The number of testimonies that I have filed where I have not been as precise about a COE versus an ROE, I would say 90% of the testimonies, this is not an issue that is raised, and that everyone just sort of understands that you're using market-driven models to establish a range for the commission to make their ROE determination. And
Okay,
it's really not as much of a dispute as I've seen here.
Okay, great. Okay, so any final redirect?
No, Your Honor, thank you.
Okay, all right, so I'm gonna say it now. We're going once, twice, three times. You're excused. Thanks very much.
Sure.
All right. So who is left from the company? Still have a number of witnesses. Let's just go off the record for a minute. So what's the company's plan for its witnesses?
We believe we've got two left who have crossed, Mr. Nelson and Mr. Stasek. We're going to have Mr. Nelson next. Don't know how much.
Yeah.
Votes have.
So questions for these witnesses? So I have a few for Nelson, Stasek. What's the level?
Cobb has a brief question for Mr. Stasek.
Well, I did want to, so why don't we take a beat here? I did want to be able to, are there questions for the renew witnesses? I think it was just Kel, right? The only one who needs to appear.
Not from the applicants.
None from Cobb.
So Kel just needs to make a statement. Okay. So how do people feel just taking Kel out of order and then maybe a break?
That's fine with us.
Okay. All right. Sounds good to me. Okay. So let's call witness Kel. There we are. All right. Ready to go. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Thank you, Your Honor. Good afternoon, Mr. Kell. Can you please state and spell your name for the record?
Andrew Kell, ANDREWKELL.
Thank you. And could you please state the name of the party that you represent in this proceeding?
Renew, Wisconsin.
All right, Mr. Kell, did you prepare and cause to be filed direct testimony and two accompanying exhibits and surrebuttal testimony in this case?
Yes, I did.
And is that testimony true and correct as of the time it was written, to the best of your knowledge?
Yes, it is.
Do you have any corrections to your testimony?
No, I do not.
If asked the same questions today, would your answers to those questions be the same?
Yes, they would.
Okay, thank you, Mr. Kell. The witness is available for cross.
Oh, okay. So I don't believe there are any questions. No. All right, great. You're excused. Thanks very much.
Thank you, Your Honor.
Okay. All right. I thought there was a statement that was why he was appearing, but that's fine. So how about we meet back at 1:15, give you a little bit of a break, not too long, so we can keep this going, but I think we deserve it. So let's go into recess till 1:15. You can turn off cameras, mics.
I think you're on mute, Judge.
Have to push like a number of buttons to get this to work. So it looks like perfect timing. You all got your pre-hearing emails in the next case to me during the break. Thank you for taking the time to do that. So while we're still waiting, I realize now that we still need to take Walmart witnesses, and I think the only questions for them are mine. So if you can take them out of order, that would be useful, I believe.
Your Honor, this is Barry Nom for Walmart. We would appreciate that if you could give me a few minutes just to make sure that both of them are certainly back.
Okay. So for the people who just joined us, we are just on a holding pattern here, just seeing if we can get Walmart witnesses up at this time, because I think the only questions for them are mine.
Your Honor, I've notified both of the witnesses and asked them to turn their videos on to confirm that they're here. But I wouldn't want to hold up the hearing.
Okay, well, at least I give you the chance. That's fine. And I should have either done it before the break if I had realized, or mentioned it before we took a break. So sorry about that. But why don't we proceed then with continue with applicant witnesses? Who do we want to call next?
Applicant calls Mr. Nelson.
Okay. Take a minute here and get this organized here. And let me change names. your first name, witness Nelson?
It's Aaron, Aaron.
Is he on the screen?
It should be.
There he is.
Okay.
Right, and we'll excuse Attorney Jackson here. Let's see if I can find that. Let's do it from the screen. It's easier. All right, great. I think we're ready to go.
Okay.
Let's swear you in. Everyone settled there? Yeah, all right, swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay.
Mr. Nelson, please state and spell your name for the record.
Aaron Nelson, AARONNELSON.
Mr. Nelson, did you prepare and cause to be filed direct, rebuttal, and surrebuttal testimony in this case?
I did.
Did you also prepare and cause to be filed 15 exhibits?
Yes.
If I ask you the questions contained in your testimony today, would your answers be the same?
They would.
Is the information contained in your exhibits true and correct to the best of your knowledge?
Yes.
Mr. Nelson is available for your Honor's questions and cross.
All right, we'll first ask for any cross at this time. No, okay. So which questions should I direct to witness Nelson? We have the general questions. Are some of those for him?
No, Mr. Stasik's going to address the general questions, but specific questions, Your Honor.
Okay. Okay, so I think try to just relay these without bringing up the testimony necessarily. But we, generally speaking, in your direct, you introduced the response rewards program. And I was just curious if the company has a plan on how it's going to promote that program.
Sure. So just a little background, the residential response rewards option became available for customers in 2007. So it's been with the company for quite some time. For small and medium-sized customers, the company uses the website with educational material showing who might benefit from the offering, as well as periodic bill inserts that go out to customers showing the various rate options available to them. For, I guess, as it relates to large customers, WPS has an account management team that works closely with them to make sure that they're on the correct or appropriate rate offering for their energy needs.
Okay. When you say large customers, what's their characteristics like? Is it a certain rate class or is it based on other characteristics?
Yes, primarily a certain rate class. So that would, as it relates to WPS, be in the CP or general primary class. So generally a customer of 1,000 kilowatts or more demand.
Okay, and then the company would proactively reach out to that company and say, I'm sorry, Pub Service would reach out to the company and say, we can put you on a different plan. Is that kind of the way it works?
Yeah, generally speaking, that's correct. Each year, I understand the company and the key account team put together a joint plan with these customers where they review a number of things, including rate options.
Okay, great. Okay, we talked a little bit about RG1 customers. You mentioned in testimony that you're able to determine generally the load on peak and off peak for RG1 customers. But I'm curious if the company is able to analyze the difference between on peak and off peak load for individual RG1 customers.
It is. So through use of WPS's AMI technology and infrastructure, we do have the capabilities internally to analyze a residential customer's usage on an interval basis. We do so through the load research activities for a number of residential customers and larger customers, customers that fit all customer classes on an interval basis.
Okay, so I'm just curious does the company then review that the difference in on-peak and off-peak loads for individual customers? Is that something it does on a routine basis?
It does, yes. Those feed into the external allocation factors as part of the class cost of service that it files in a general rate case.
Okay, so if it finds that an RG1 customer would save, would save money by switching to a time of use rate, does it inform the customers about that?
No, I don't believe so. On a global scale of all residential customers, I don't believe the company at this time has interval data available to perform such calculations automatically or recurring through the system.
But it has the data for on-peak and off-peak usage for individual customers.
It is, and that I would like to clarify is just more of a manual process where an analyst goes and pulls the data to further study it when needed.
Okay. So could that process be automated?
Because that's getting into the technical information side, I'm not sure. While I would like to think that it exists, it's not in place today. And I don't know the work that would be required to make such an effort.
Okay, but if you had data that says a user uses more off-peak energy than on-peak energy, that person would save money by switching to a time of use rate.
There's that potential.
Okay. Oh, that's interesting. Okay. So, so then another thing I noticed, and this is in direct, excuse me, might be useful to pull this one up. Okay, yeah, it looks like, so I'm looking at your page 11 of direct. And I think at this point you're talking about how you develop the energy charges for the optional residential TOU offerings, RG3 and RG5. And then towards the bottom of the page, there's the statement, the current ratio of on-peak to off-peak residential energy class charges is set at about 3.1 times for RG3 and 4.0 times for RG5. And then you're proposing to change that ratio for RG3 to 3.2 and keep the ratio for RG5 to 4.0. I was just wondering, what was the basis for making the change to RG3?
Sure. So for RG3 as well as RG5, those rates are developed to be revenue neutral from a typical residential standpoint with its corresponding flat rate. So that marginal change represents the change necessary to make sure that if a typical residential RG1 customer transitions to the time of use rate, they don't realize a benefit without first modifying their usage or consumption patterns.
And is the change necessary because the average customer's usage has changed, or what's the change represent?
There could be a number. It could be the average usage customers, the customer's usage has changed, or it could be related to the level at which rates are set generally across the residential classes. The RG3 off-peak is related and identical to RG5. So from a break-even standpoint, it could be based on the level at which rates increase or the average usage per customer.
Okay. But you don't know why the change was made specifically?
I don't know specifically which one would have caused the change, other than reviewing the neutrality of the rates across the class.
Okay, so that was the purpose of the change.
Yes.
We just don't know the details of what drove it. Okay. Okay, so then generally speaking, how many RG3 customers are there?
Generally speaking, there's less than 7,000, roughly 6,900.
How about RG5?
That's an even smaller number. So there's roughly 2,500 customers.
Okay. And what activities does Wisconsin Public Service do to conduct, what did I say here? What did I write here? No one's checking this before it goes out. So what does Pub Service do to promote and inform eligible customers of a TOU option?
So for the general time of use options, that's very similar to the response rewards options we just discussed a moment ago. WPS utilizes its website with educational materials, as well as provide periodic bill inserts. And then the same thing with the large customers involved with the WPS key accounts team.
Do you suspect that there are more customers eligible for those rates than are currently taking those rates?
Yes, that's possible. Just looking at the size of residential customer accounts in general.
Okay. So I'm sorry, I did skip over a couple of questions here. Can you just tell me the number of CG1 customers?
For CG1, there's roughly 47,000 accounts.
And CG5?
In CG5, there's roughly 1,400 customer accounts.
Okay. All right, great. So I did have a number of questions about the tariff, that the exhibits that you have related to the tariffs, and I couldn't fit them on the that offered evidence list. I did want to review that here. It starts with your exhibit 10, and I think we're looking at the revised exhibit 10. Is that the current version?
Yes, that's correct, Your Honor. There should be a revised 10.
Okay. So there's the RER1 tariff. And maybe it's just my confusion, which is completely normal. But I was just curious, how does this differ from a parallel generation interconnection agreement? Is it just the size, or?
So for a parallel generation interconnection, the customer will own those facilities on their premise. As it relates to the renewable energy rider, the company will own and maintain the facilities, and they don't necessarily need to be on the customer's premise, as I understand it.
Okay. So you do mention in the special terms and provisions that there's a service agreement. involved in this. And I was just wondering if we have a copy of that on the record, a model version, what does that look like?
I don't believe that's on the record. And to my understanding, I think it's still in development.
Okay. Is the company going to seek approval of that from the commission before using it?
Yes, that's my understanding.
Okay, so it'll be a separate filing. Okay. Is that a separate filing outside of this case, I would assume, anyway?
Yes, I think that's reasonable.
Then, yeah, I did want to mention, so again, my confusion, most likely the statute cited on 0.6 here, and let me just get the sheet number. It's, no, there's the sheet number. So page 2 of 2 of your exhibit, item 6 cites Wisconsin statute, okay, PSC 196, 192. And I'm just not sure what that means, I guess. I don't know if that's really pointing, and I guess it's probably not pointing to PSC 119, which is what I was assuming it was before, but maybe I was looking for statutes, not rules. Maybe that's my.
Your Honor, subject to check, I think that's probably a typo. It's meant to point to WIS 196.
I'm sorry. Subject to check, it's probably a typo, and then I couldn't hear the numbers you said after that.
It's probably intended to point to WIS stat 196.2.
No, still didn't hear you.
It's probably intended to point to WIS stat 196.192.
Thank you.
Yeah, okay, that was what I had checked before. But. Okay. So this is 196, 192, the market-based compensation rates and contracts. Is that the section you're intending?
Yes, that sounds appropriate, as any excess energy delivered to the company will be priced at a market-based rate.
Okay. So then it's nothing set in the tariff.
I'm sorry, Your Honor, could you?
It's not a rate set in the tariff. It's set by contract.
Yes, it's set by service agreement, but will be based on the parallel generation rates, also on WPSC's tariff books.
Okay, where does it say that?
That is under special terms number 1F.
Okay.
It defines the excess energy rate.
So what's why would there need to be a contract then if it's going to be set with the parallel generation rate?
The contract has a number of parameters that will be defined: the size of the facility, the price at which will be recovered, and other additional provisions, and that'll be specific to each participating customer.
Okay. Okay. All right, that's good. Thanks. I got a few more. I can find it now. Okay. Okay, yeah, I think so. Let's just turn to Nelson 13. I think that one should be pretty simple. So I was just curious, sheet. So this is your exhibit 13 on sheet E4.01. It looked like the availability section is revised. There's a lot of R's in the margin, and then N's and R's. And to my understanding, that means there's revisions and new sections being added. And I was just curious if we could get a strike and score version of that testimony of that tariff, so we can see where the changes are.
Yes, we can file a revised version. So I understand that on that specific sheet, there are no changes from the current draft. And those R and N's, I believe, were an oversight. So we can file a revised version with those stricken from the sheet.
Okay, great, thanks. And then, sorry. Yeah, and I did notice, boy, where is it? I think it's, so this this sentence, the last paragraph of the applicability, it looks like the date is already passed, the March 31st, 2011. So I don't know if it's okay to remove that now. What is your opinion on that?
Yes, I believe WPS would be okay removing that, as the last date is December 31st of 2021, which has passed. So I don't see any issue with that.
Okay. Oh, and I think I thought I had more. Let me make sure. Oh, yes, okay.
Your Honor, on that last point.
Yeah.
The last sentence of that paragraph, I think, still remains relevant. Do we need the rest of the paragraph to establish the context for when someone might be grandfathered?
Mm-hmm. Yeah, okay, well, I just pointed out that if you have a better way of drafting that, go ahead. I just didn't know if you needed all of the dates and the dates that have already passed. Perhaps maybe you just need one date to establish who's grandfathered now.
Okay, we'll work on that.
Okay. And a couple questions on your direct testimony. So this is direct, page 12, I think. I didn't put okay, I don't have the exhibit number on here. So I had some questions about the LS1 tariff. And that might be exhibit 9, possibly.
So Your Honor, LS1 would be in Nelson 6.
Oh, okay. Page 12. So the LS1 tariff, making a number of changes there, and I was curious about section 1, the service rules, sub D, and so the way I read it, I guess, so sub D, generally it's saying that the company will at the customer's expense make changes, remove and reinstall any properly operating lighting facilities that are being contracted under this rate. I'm just paraphrasing here. If it's requested in writing by the customer or as required by a governing authority. So my question relates to municipal customers, municipal authorities who are customers of the LS1 tariff. And I guess, first of all, that's possible, right? You can have a municipality taking service off of LS1.
Yes.
Okay, yeah, I just wasn't sure. Okay, so I guess my question is one effect of that section 1D, is one effect of that to preclude any municipal authority under Wisconsin statute 192.017. Is it to preclude the municipal's authority that it has under Wisconsin statute section 182.017, which is its authority to, I think it's to order use of streets and order utility to remove facilities.
While he's looking, you said 192 and then you said 182.
Yeah, it's 182.
It's 182 both times.
Yeah. Yes. And I can bring it up here.
Your Honor, can you repeat the question? I'm sorry, I lost.
That's okay. Yeah, and I kind of lost myself, so it's fine. Hang on. Let me get this statute. This was written in a flurry on weekend. So let's see, 182, 187. So here's our statute. It's Wisconsin statute 182.017. It's the authority of municipality to regulate the use of streets and to obligate a utility to remove facilities at its expense. That's how I understand that statute. So the tariff, if the municipal authority is taking service under LS1, seems to be saying that if a municipal customer asks the utility to remove the lights and poles, it can't charge the company for that. It would be paying for that itself. I just want to make sure if that's your understanding of how LS1 operates. Is that?
It seems like more of a legal question, Your Honor, and I guess I'd say that a utilities tariff is not going to trump a contrary statute. The analysis.
I don't need a legal analysis. I'm just making sure. I just want to make sure the tariff is accurate and is what the company intended. And so knowing that there may be a conflict, is this what the company intends to continue to put in the tariff, or is there something else that may need to adjust?
That is something that I may need to look at further. My understanding of that paragraph is to ensure that the company's costs are covered at the time those facilities may be moved.
Okay. Okay, so just so you know, there may be a similar conflict and something that you can look into with, I think it's paragraph 1.4 of the service rules section. Because it's without the expense of the company. So let's leave it like that. I'm just flagging out that for you guys to take a note of. Then So there's also on the second. Okay, so sheet E 4.44.2. I guess my question is more kind of general here. It's this is based on outdoor lighting service customer owned, and it says that the tariff is closed. But then I'm wondering why there's a section on the bottom of that sheet that's labeled extension of service. And that lighting facilities will be extended upon request. So I'm just curious, why is there extension of service if the tariff's closed?
It could be for existing customers if they want any revisions. However, my understanding is the majority of these changes were reorganization or moves from one section of the tariff to the other. And I believe this was already a existing provision of the tariff. So it wouldn't be necessarily a new add.
Okay, I do remember that in the testimony. So it would be existing customers extending lighting facilities out to a new area.
Yeah, I believe that is all that would be applicable to, since it is closed to new customers.
Okay. And so then sheet E 4.46, then service rules 1, the section B indicates that, so this deals with if there's an outage in the equipment, and talks about diagnosing and maintaining the system. But there's a section that says if so during the period of outage, I think that's what this is relating to, that during the period of outage, no credit will be allowed for periods during which lamps are out of service. And I'm just wondering, what's your opinion about that? What's the basis for that provision in the tariff?
Having just read through this part of the tariff, I believe it's relates to the first sentence where the company will initiate a response to diagnose the issue with the particular fixture.
So it's between the time of, well, I guess, is there a time frame that we're talking about, or?
It would have to be within the 72 hours after being notified by the customer, which there may be additional time on the customer's end from when they identify the fixture as being out.
So the period of time where no credit would be allowed is the period of time between the outage and the notice by the customer to the company?
I think it would be until at which time the company could determine the particular issue with the fixture.
Okay, well, if that could be changed, if that language could be changed to reflect more specifically what time period you mean, I think that would be useful to prevent any misunderstandings. I think that's it. That's all I could get through the time I had. So that's all we needed to discuss. But all right. Yeah, I think that's it. Any questions based on those? Any cross based on what I was asking? No. How about redirect?
No, thank you.
All right. Okay. Let me just check my list here. I think that's it. Okay, great. That's all I had. So you're excused. Thanks very much.
Thank you, Your Honor.
All right. James Goldschmidt, returning. James Goldschmidt returning for WPS, Your Honor. And the company calls Mr. Stasek.
Your Honor, this is Barry Naum from Walmart. I do believe that, excuse me, both of Walmart's witnesses are present. If you still would like to take them out of order, I don't want to interrupt the company, but if that's your desire, they are both here.
I think that'd be useful if we can just get them done. So let's switch over to Walmart. All right, we all set?
Yes, Your Honor. Walmart calls Alex Cronauer.
All right, great to see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
Good afternoon, Mr. Cronauer.
Good afternoon.
Can you just, for the record, state your name?
Sure. My name is Alex Cronauer.
And by whom are you employed and in what capacity?
I work for Walmart and I'm a senior manager on the energy services team.
Great, thank you. Mr. Cronauer, in this proceeding, did you cause to be filed one statement of direct testimony with 5 accompanying exhibits?
Yes, I did.
Do you have any corrections to that testimony or those exhibits today?
I do not.
If I asked you the questions that are contained within your direct testimony, would your answers today be the same?
They would, yes.
And do you adopt this as your evidence in this proceeding?
Yes, I do.
Thank you, Your Honor. Mr. Cronauer is available for your questions and any cross-examination.
All right, so any cross at this time? Okay, just wanted to double check. I'm not finding you, my notes, but here you go. Okay, yeah, so I just have those general questions. Which one should I direct to this witness?
Your Honor, Mr. Cronauer is Walmart's ROE witness.
Okay, so I'll ask the ROE question. Excellent. All right, so just getting the poll from parties here. To the extent you have a preference, or Walmart has a preference for the following, state it and cite to where it appears in the record. And those things would be cost of equity and return on equity.
Sure. I apologize. I'm not sure I understand the question.
Oh, okay. So trying to get a sense of each party's position on cost of equity and return on equity. Just what number are you proposing as the appropriate cost of equity and or return on equity, or both, if you have numbers for each one? And then if you could just tell me where I would find that number on the record, if you have it presented somewhere already in testimony.
Sure. So my testimony did not give a specific ROE. And to that extent, Walmart generally does not provide specific return on equity recommendations. Having said that, the main purpose of my testimony is to provide context of what we are seeing around the country in terms of other jurisdictions and other states and the return on equities that have been awarded historically. So having said that, I do not have a specific return on equity recommendation.
Okay, and same answer for cost of equity?
Correct, yes.
Okay, then that's all I need to know. Excellent. So anything else based on those questions? Any other questions from parties? Okay, any redirect?
No, Your Honor.
All right, great. Thanks. You're excused.
Thank you.
Okay, thank you, Your Honor. Walmart now calls Andrew Teague.
Okay, there you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Right. Go ahead.
Great, thank you, Your Honor. Good afternoon, Mr. Teague. Can you just please state your name for the record?
Andrew Teague,
And by whom are you employed and in what capacity?
Walmart as a senior manager.
And did you, in this proceeding, Mr. Teague, cause to be filed one statement of direct testimony with 4 accompanying exhibits?
I did, yes.
And do you have any correction to that testimony or exhibits today?
I do not.
If I asked you the same questions that are contained within your testimony, would your answers today be the same?
Yes, they would.
And do you adopt that testimony and exhibits as your evidence in this proceeding?
Yes.
Thank you, Your Honor. Mr. Teague is available for your questions and any cross-examination as well.
All right, so any cross at this time? No? All right, witness Teague, thank you. So my question will be similar in form to the previous witness, but I'm trying to get a poll from the parties. And for your question, it'll be related to revenue requirement, electric cost of service study, gas cost of service study, and revenue allocation. So I was curious if Walmart had a preference for those things and to cite to where it appears in the record currently.
In terms of cost of service, Walmart is supporting will align with the company's rebuttal, supporting WIAG and staff in the cost of service studies.
Oh, okay. I'm a little confused. So a particular method, is that what you're saying? There's a particular method in the various methods of costs, and this is electric costs.
Yes.
So is there a particular method that Walmart prefers, or is there a number of those methods that it agrees with?
It agrees with the methods established in Nelson's rebuttal.
Okay.
Good.
I guess I don't know if that answers the question. So I think the company's most, well, I haven't gotten to them yet. But my understanding is the company prefers method 4. Is that the method that Walmart prefers?
It's my understanding in the rebuttal, Nelson made a statement in terms of support of the revenue allocations by WIG and also staff.
I'm sorry, and also
Staff.
thank you. Sorry, there's voices behind you.
Sorry,
Okay.
sorry.
Okay, and that's revenue allocation you're talking about.
Yes.
Okay. So my questions was revenue requirement. So there's some debate over revenue requirement. There's adjustments from staff, and then there's the company's proposal. I mean, if you don't have a preference, that's fine. Walmart doesn't have a preference.
We don't have a real preference, no.
Okay. All right. And then for e-cost, any preference?
No.
And for revenue allocation, any preference?
No.
Okay. All right. That's fine. Okay. Any questions based on that? Any redirect?
Your Honor, if I could maybe just provide a question of clarification on redirect. Mr. Teague, when you testified that you support the company's analysis in Nelson's rebuttal testimony, are you specifically saying that you support his statement, or at least his indication, that WIAG IEG and staff's allocation strikes a better balance between residential and commercial?
Yes, sir. Yes.
Okay, thank you.
Okay. All right, great, thanks. All right, thanks, you're excused.
Thank you.
Great, thank you, Your Honor, and appreciate the deference by the company as well.
Okay. So should we move on, company witnesses?
Yes, Your Honor, the company will recall Mr. Stasek.
All right, I can just move on here. There you are. All right, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Good afternoon, Mr. Stasek. Would you please state and spell your name for the record?
It's Richard, middle initial F, Stasek. Last name is spelled S-T-A-S-I-K.
Thank you. Did you prepare or cause to be prepared and filed in this case direct, supplemental direct, rebuttal, and surrebuttal testimony?
I did.
And did you also prepare or cause to be prepared 13 exhibits supporting that testimony?
Yes, I did.
To the best of your knowledge, were your testimony and exhibits true and correct as of their filing?
Yes.
Is there anything in your testimony or exhibits that you wish to change or correct today?
No.
Mr. Stasek is available for clarifying questions and cross.
All right, any cross?
Cobb has just a brief bit of cross for
Okay,
Mr.
go ahead.
Stasek. Good afternoon, Mr. Stasek.
Good afternoon.
In your direct, you describe your role as overseeing and managing WEX regulatory matters in Wisconsin and Minnesota and Michigan as well. Is that an accurate characterization?
It is.
So in that capacity, did you oversee the preparation of the company's originally filed electric revenue allocation in this docket, the one that was filed on April 28th of this year?
That's correct.
So in preparing that original rate application, did you receive direction from upper management that the proposed revenue allocation should be designed so as to limit the rate increase to residential customers?
No.
Are you aware of any such guidance from upper management that is a directive or guidance that the proposed revenue allocation be designed to, within reason, limit the residential rate increase?
No.
Okay, thank you. No further questions.
Okay, any other cross? No, all right, I did have one question. So what were any of the general questions? Should those be directed to witness Stasek?
Yes, Your Honor, I believe Mr. Stasek is prepared to handle your general question 1A.
Okay, great. So you've heard it a number of times, but I'll try my best to say it again. To the extent WPSC has a preference for the following, state it and cite to where it appears in the record. And for you, those would be for electric and gas service, the revenue requirement, E-costs, G-costs, and revenue allocation.
Certainly. I'll try to take them in that order just to kind of keep things sequential, Judge. So on the revenue requirement, what I would say is our as filed position from our supplemental testimony, July 8th, which is covered in company witness Zagant's revised exhibit 1, schedule 1, would capture the base rate revenue deficiency and requirement for both the electric and gas utility for WPS. And that would be our preferred revenue requirement.
Okay, continue.
Okay, I just want to make sure. Okay.
Yeah.
Then as we get into the cost of service, I will take the electric cost of service first. Our preferred, while we believe all of the cost of service methods, you provide some relevance to the commission's consideration, the one we file and prefer is cost of service method 4. That can actually be found very directly in my SIR rebuttal, page 4, lines 7 through 9. On the gas cost of service, our preferred method is the cost of service method A, noting it is the same as our base cost of service. So that's really the same thing. And so there in the supplemental direct, hold on a second. No, I'm sorry, that's in Bill Korducky's direct testimony, page 2, lines 3 through 5. And then as far as revenue allocation goes for electric, our preferred method would be consistent with staff and WIGs. And that's covered in Nelson's SIR rebuttal, page 2, lines 6 through 9.
Okay, great. Thanks. I appreciate that. So then one other question I had dealt with your direct pages 11 through 12. And it talked about the method for determining an energy-related portion of production plant costs that are allocated to customer classes. And there seemed to be a change in how that's done. And I just didn't know if that was explained in your testimony, why that change occurred.
Yeah, looking through your question, it probably, it's one of those things we could have added a little more context. So to respond to that question directly, really we're using, just for context, we're currently using the prior method uses forecasted data. The new method was using historical data. And so really the genesis behind that change was to provide the cost of service studies that will show a more precise and transparent allocation of those energy related costs when compared to using a forecast for that allocation.
Okay, great, thanks. So any questions following mine from parties? How about redirect?
No redirect, Your Honor.
All right, thanks very much. Okay, great, thanks, you're excused.
Thank you.
All right, so any other company witnesses?
Your Honor, if we could have a brief moment just to confirm that we're wrapped up, I'll be back with you shortly.
Okay, thanks.
Your Honor, with your indulgence, could we take a 5-minute recess just to determine whether we have any further redirect for Mr. Stacey?
Sure, that's fine. Take a 5-minute recess and be back at 2:20.
Thank you.
Okay, we're back. We'll get on the record. Any questions for witness Stasek?
Yes, thank you, Your Honor. We do have a bit of redirect for Mr. Stasek, just to clarify the record before we close the case, the company's case.
Okay, go ahead.
Mr. Stasek, earlier in the examination, you were asked some yes or no questions by Cub about whether upper management directed the company's initial position on cost allocation favoring residential customers. Do you recall those questions?
I do.
Is there anything that you wish to add to clarify or contextualize your answers to those questions?
Yes, I would. When asked the question by Cub's attorney on whether or not me or my team was directed by senior leadership, I took that question to indicate that we were given a specific target to hit by our senior leadership. That in fact did not occur. However, as we prepared our direct case, what we did do was prepare a series of revenue allocation options based on the cost of service studies that are in the record in this case. We presented those to senior management with a recommendation to go with the one we proposed in our initial filing. When we made that presentation to senior leadership and made our recommendation, they ultimately approved the initial revenue allocation that was included in Mr. Nelson's direct testimony.
Thank you. That's all I had.
Okay. Any cross based on that redirect?
Your Honor, Steve Heinzen for Week. I don't have cross based on that redirect, but I do on one of Mr. Stasek's earlier answers that if I could have the opportunity to ask him, I would like to.
Let's make it brief.
Sure. Mr. Stasek?
Good afternoon.
Sure. Hi. Good afternoon. I'm going to ask you a question just in connection with the utilities position on revenue allocation that you were asked of from Mr. Newmark just a few minutes ago. Do you have in front of you, or do you recall the rebuttal testimony of Mr. Nelson?
I do not have it in front of me, but can try to pull it up.
Okay, if you could, that would be helpful. It would be on. I would just like you to reconsider what your answer was with respect to the position that utility has with respect to revenue allocation, as described by Mr. Nelson, at least on page 2 of his rebuttal testimony, beginning at line 6. And you don't have to read it out loud, but line 6 through line 8, if you could just take a look at that, that'd be helpful. And I'll ask you a question once you've had a chance to read it.
Okay, I've read, I'm assuming you mean lines 6 through 9 on page 2?
Yes, that's right.
I have read.
Okay. And does reading that from Mr. Nelson's rebuttal testimony suggest that your answer could be modified in some way as to what the position of the utility is with respect to revenue allocation?
I guess I would say yes, it could be a slightly bit more crisp. So the answer there would be we support the revenue allocation proposed by Ms. Maney of WIG, which while closely resembling staff's is not identical. So the short answer is yes, we would recommend following the revenue. We would recommend the revenue allocation for electric rate setting proposed by Ms. Maney.
Okay, thank you very much. I have no further questions.
All right, great. Any redirect?
Not this time, Your Honor.
All right. All right, so any more company witnesses?
No, Your Honor, we're finished.
All right, great.
Thank you.
All right, let's move on. So there's cross for Keim and Singletary. Just wondered if I think WIG witnesses, they only have questions posed by me.
Your Honor, WIG does not have cross for Mr. Singletary after all.
Oh, okay. Yeah, that's not my. So I'm wondering if there's any witnesses where only I have the questions. And I think that was Bauer and Manny. Anyone else? So there. Well, let's just go off the record and do this over. So as where we sit now, there's no questions for Singletary. Is that what we're saying?
Yes, there are none from Weed.
Okay, but the company has questions.
The applicant will have questions, yes.
So I just want to be able to take witnesses who only I have questions for, the general questions. I believe right now that was Bauer and Manny. Is there anyone else? No. All right. Let's do Wig first then, and just have them get those questions from me out of the way.
Okay, they're not.
Not available. Oh, okay. Forget it. They're not available. Okay, then we'll push on then. So let's move to Cub and have you call your first witness.
Thank you, Your Honor. Cub calls Dr. Stephen Keim. There he is.
All right. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
Okay, I'm going to appropriate your name from the other device.
Dr. Keim, could you please spell your name for the record?
Yes, the last name is K-I-H-M as in Mary.
And did you prepare and file or cause to be filed in this proceeding direct rebuttal, rebuttal testimony, and 3 exhibits along with accompanying errata and 1 revised exhibit?
Yes, to all of those.
And inclusive of the errata and the updates in the offered evidence list, is that testimony and the information in those exhibits true and correct to the best of your knowledge?
Yes.
Do you have anything to add to your testimony at this time?
Yes, I would like to make a couple comments based on Ms. Bulkley's sir rebuttal and sir rebuttal, and I'm hoping actually that I can provide some clarification, and I'm actually looking to you, Your Honor, because I'm starting to see why there is such a discrepancy. If I could just step through a few things, if I could refer you to my direct at page 51, please.
Okay, let me get there.
And if you could, yeah, to the figure there. So I'm not going to talk this moment about merit. I would just want to talk about definitions again. So Ms. Bulkley has said this morning that anything that comes out of a model is really a cost of equity. So we're now not even talking about the return on equity. We're just talking about this one variable. And we can see a really wide discrepancy. And I think I actually am starting to understand why, because her definition of the cost of equity is also different from, we use the standard corporate finance definition. She has a different definition of even that variable. And if you would now just bear with me for a second here, if we could go to her sir rebuttal testimony at pages at the bottom of page 2. Yeah, so that last sentence, well, we can look at this paragraph. Considering that Dr. Keim estimates a cost of equity between 6 and 7%, which is a level he admits would create no wealth for shareholders, which is a key point. Dr. Keim undermines his entire thesis about the estimation of the cost of equity provided in his direct testimony. If investors would be unwilling to invest at 6 to 7% return, and if you would please just finish that out on the next page, then by definition, the results of his analyses do not represent the investor required cost of equity for the company. I will go to, if you can see this, a text valuation, which is an applied text. It says when the ROE equals the cost of equity, there is no value created. Ms. Bulkley thinks the cost of equity creates value for investors. The definition of that variable in finance, the mainstream definition, is that the very essence of a return equal to the cost of equity is that there's no value created. So I'm trying to make the point here that we do not have what would be called in rhetoric stasis. We're not even agreed to any definition here. And so we will continue to sort of holler at each other because she's trying to find a different number. We're trying to find, by definition, the corporate finance definition, the return that is value free. There's no value. That is the definition of the cost of equity. And if you could bear with me just a little bit more, if you would go to page 4 of my direct, excuse me, page 5. Oh, no, I'm sorry. Page 26 of my direct. The quote, if you go up a little bit. So this is from Stuart Meyer's article. He's an MIT finance professor. He says that whenever you have an opportunity, now we're going to say that an ROE greater than the cost of equity or cost of capital, that is immediately captured by the existing investors as a windfall. The prior testimony of Ms. Bulkley, she believes that returns on equity can somehow create wealth for new investors. That's actually impossible in a market. If you bear with me a few more times here, if we go to page 15 of my direct. So in the quote there, what she's trying to do with her definition is the impossible. So as Alfred Kahn says, any attempt by a commission essentially to put a higher return on equity would be self-defeating because investors are simply going to bid the price up immediately before the company goes out to raise capital. There is no way for a firm to create value for new investors because the market's too fast. And so when we find the cost of equity, not only is there no value for new investors because there actually never is any value for new investors, the market's too fast for them. There's also not any value for existing. So it's a null point. We're trying to find a null point. And that is the definition. That is not her definition. Her definition is that some kind of value opportunity, but that's actually impossible. You never can create a value proposition for new investors. As I said, the market is too fast, but this is not just a finance problem. I am now going to refer to an article, and I will spell the author's name for the reporter, but it is from the Minnesota Law Review, Temporal Perspectives, Resolving the Conflict Between Current.
Your Honor, can I break in here? We're introducing new authority on sir rebuttal on the fly without any parties having a chance to take a look at the materials. This is pretty far. I mean, we're waffling between rehashing direct testimony and getting very far afield from what the issue.
Your Honor,
case.
One at a time.
I'm sorry. I didn't hear the end of Mr. Wilson.
My apologies.
Direct testimony and getting very far afield from.
What the issues are in the case at this point.
Thank you.
Okay, any response from Cub?
This is in direct response to Ms. Bulkley's sir rebuttal, which was filed this morning at 9:30.
Yeah, I think, well, I'm going to allow it just because of the timing in this case has been very, expedient, let's just say the least, but also, parties have been citing in this docket many articles without providing the documentation. Usually, it could be a treatise or a book, and so at this point, I'm going to let it in. I just would advise Dr. Keim to be succinct and brief in his explanation. And if you could give a citation to this article so that it can be double checked.
And just to be clear, Your Honor, what I'm trying to do is to say that I think we need, probably outside of this case, a pause to actually, if we keep talking past each other on these definitional issues, we're never going to resolve any of these things if we're using different definitions. So my goal here is not, as I said, not to argue merit in this. I'm trying to say that we are just headed in different directions. And I can just, this will be my last piece, but the law article, Minnesota Law Review, it's entitled Temporal Perspectives, Resolving the Conflict Between Current and Future Investors. And the article comes down strongly, and it says managements have a duty only to the existing investors. They never have a duty to the new investors, except to be fair in disclosure. But all of the focus in this case should be on creating wealth or for the existing shareholders, which is what the cost of equity and return on equity difference is all about, which is the staff Cubs frame. Ms. Bulkley is over on the other side of the equation, other side of the line. Maybe there's a theory or something that she has to support that. I'm just saying that what she calls the cost of equity and what we call the cost of equity, fundamentally different variables. We're using mainstream finance. That's why all of those black bars in that first graph that I showed you, which are corporate finance, are in our camp. She has a different view. And I think you're hearing me, Your Honor, that I'm just saying that we will never find resolution here if we can't even define the single variable, let alone the ROE and the cost of equity distinction. We can't even define the cost of equity consistently. That's my point.
That's fine. And that's what the commission's for. So they'll resolve this issue. Have no fear.
Right.
Okay. Anything else?
I had just a couple other comments on her sir rebuttal very quickly to she says that Mr. Singletary and I haven't used models. That's because we're being consistent with the framing. In the Hope decision, the court says they shouldn't be models. They should be based on judgment. That's what we've done. And let's see. There's one thing that she talked about, the fact that I put in an interest rate study, but did not provide the background documentation. That's because I completed the study in another project. And normally we don't provide the background data for a study completed in another case. Although I actually have that data, I could go get it. I could submit it, but that was for my exhibit. Let's see, it was in my original. I think it's my exhibit 1. It's the interest rate data. So to follow protocol, I would normally not provide data for a study that I completed for another project. But if you would like me to do it, I would. I can do it. So I look to the court, or to Your Honor, as to how you want me to proceed.
If it helps complete the record, you can submit that. What exactly is it?
It's a study of interest rate forecasting accuracy using the survey of professional forecasters. And it shows that for 21 years in a row, those forecasts were too high. It's a spreadsheet that I did for a client as part of my consulting work. I can pull that in and just submit it to either to the record or as a discovery response. But normally I would not submit, working data for another project. Yeah, it's the data behind that study that Michaela Calice, Calice, and I did originally for the Hawaii Commission, but we updated it for the Rocky Mountain Institute recently. So I just put in the final study.
Your Honor, could I be heard on that?
Yeah, go ahead.
Now we're going beyond articles and law reviews to non-peer reviewed data that Mr. Keim admittedly developed in some of the proceeding, if it's allowed into the record here at this time, we will have no meaningful opportunity to test its veracity, ask discovery about it, or ask Mr. Keim questions about it. It's simply not fair to the applicant to allow this sort of material into the record at this late.
Okay. So I think the basis for the offer is to respond to Sir rebuttal about the lack of this data existing. So that kind of puts us in a bind. Hang on, let me bring up, so the search for this. And I don't disagree with you. This comes late in the process, but I guess my point is, so does the criticism. So I want to check what witness Bulky had mentioned in Sir. Oh, wrong docket. Sorry. Okay, so here's the Bulky Sir. Where is the criticism, Dr. Keim?
I'm sorry, my notes are a little, bear with me here.
That's it there on the bottom of page 6, going on to page 7, I believe.
Yeah, yes, that while Dr. Keim suggests he has prepared a study, then if you follow that sentence.
Okay, hang on. It's just
I
let's
guess
go off the record for a second. Let's off the record for a second.
Your Honor, I believe Ms. Buckley's point there was, if this was going to be included in the record and it was supporting something Dr. Keim said in his rebuttal testimony, it should have been produced as an exhibit at that point. You don't get
It was an exhibit in my direct.
He's referring to the work papers behind an exhibit, his exhibit 1, which was introduced with his direct.
So it's in the record or it's not in the record?
It was filed
The
as
study
an
is in the record. The work paper that she refers to is not. She says study and work papers. I'm not sure what she means by study. But what we would call the study is exhibit 1. What we would call the work papers, Dr. Keim is happy to provide if it would contribute to the record. Per Ms. Bulkley's request.
Okay, so let's get on the record. So I've heard statements on and off the record from the applicant and Cub with respect to Keim Exhibit 1 and the background data that supports or purportedly supports that exhibit. The issues raised by witness Bulky on Sir rebuttal with respect to the lack of the background data being in the record. I guess at that point, she didn't even know it existed. Now we know that exists. And she refutes that study and cites the San Francisco Federal Reserve for evidence that I believe contradicts Dr. Keim's analysis. I think the way that I'm going to have to rule on this, I don't recall, and this is probably my oversight, if I'd asked for any objections to the Sir rebuttal, because the opportunity to object to the prior filings is at the deadline of the prior of the filings before. So, for example, if rebuttal is to be objected on, it should be objected on by the deadline of surrebuttal. And if surrebuttal should be objected upon at the hearing, as well as surrebuttal. And I don't recall, I know I did not ask for objections on the record to surrebuttal. That doesn't mean I really need to ask, but I failed to do that. So I just want to mention that. But I believe the appropriate time, what we really should be looking at is, does the surrebuttal, should the criticism of Kimes Exhibit 1 have been done on rebuttal, not surrebuttal? And so this being an inappropriate time for criticizing that data, is there a timing problem here? But Cub having failed to raise that objection, I'm inclined to allow the record to stay as it is, and having ostensively accepted the surrebuttal as it was stated at this point, it should have been objected to, but it wasn't. So let me hear comments on that. I'll start with Cub.
Cub doesn't object to the inclusion of this evidence. We're just offering to provide the work papers in response to this rebuttal, because we have the work papers to support our analysis.
I understand that, but that kind of begs the question. So it's coming in so late is the problem. So her criticism comes in so late.
Right.
It's out of time, but it was not objected to. So really, there's not enough time to get your response in.
Correct. So this would be something that Dr. Keim is attempting to address now.
Right, I understand. Okay, any response from the company?
With all due respect, Your Honor, I distinctly recall you asking for any objections to surrebuttal this morning and receiving none. But given that we continue to object to admission of these work papers into the record at this time.
All right, I think the way we'll handle this is we're gonna have the Cub offer this as additional evidence with a motion that can then be objected to, and there can be a provision for either objection or filing of countervailing evidence. If the data looks good and can be accepted, we can just get a stipulation to it. If not, I'll have to rule on it later. All right, so that would be a Keim Exhibit 7, I believe. So we're on the record, right? Okay, it's like, oh no. All right, so I'll make that Keim 7. Do we have a title, working title we can call Cub Keim 7?
Your Honor, I would call it working papers to support Keim Exhibit 1, if that works.
That's good enough. Okay, so we're done with supplemental testimony.
Yes, Your Honor, I'm finished.
Okay. All right, so I have no question. Oh, well, are you the appropriate witness? Well, I think we know where he's. Can you just give us the number?
Yes.
Of cost of equity and revenue requirement.
I'm sorry,
Yeah.
the number, he was laughing while you were talking. Can you just give us the number?
Of cost of equity and revenue requirement that COVE prefers.
Thank you.
And I apologize if I was laughing. I didn't mean to. So you'll also have to ask Mr. Singletary because we have a joint ROE, but I have the cost of equity based on my surrebuttal update. It is 6.3% to 7.8% is the cost of equity, and the return on equity is 9.1% for this case.
Okay, great. All right, that's all I have. Any cross?
Yes, Your Honor.
Okay, go ahead.
Good afternoon, Dr. Keim. I'm Joe Wilson, one of the lawyers for the applicant here.
Good afternoon, Mr. Wilson.
Dr. Keim, how many times have you testified before a regulatory commission on the topic of establishing authorized ROE?
Oh, boy. Hundreds of times. Almost all in Wisconsin, because I worked on the staff for 21 years and I was the rate of return witness for almost all those cases.
Looking at your credentials, discussion of your credentials and your direct testimony at pages 2 and 3. Unless I'm missing it, I see a reference to some testimony in an Oregon tax court on cost of equity, but I do not see other references to you providing cost of equity or return on equity testimony.
That would have occurred from 1980 to 2007. That's when I did most of my testifying.
And how many of those times, just put a percentage to it, how many times have you testified in favor of the approach that you're advocating here, which is to determine a reasonable estimate of the cost of equity and then set a final ROE that balances interest of utility shareholders and customers?
And that has essentially been the commission staff approach since I can remember. If we look at like Mr. Adams' testimony, in this case, he has cost of equity models in the sixes and an ROE recommendation of 9.9. It's sort of the standard approach in Wisconsin.
All right, but you're advocating much more deliberately taking a two-step approach to that than staff has done, at least in the recent past. Is that fair?
It's fair to say that we're asking the commission to be explicit about a two-step process. I think there has been one, but you're correct. We're asking for a more overt recognition of that.
As an aside, could the final authorized ROE balancing the interests of utility customers and shareholders be lower than the reasonable estimate for cost of equity under the approach that you're advocating?
Could I have that question read back, please?
Sure, read that back.
Question as an aside, could the final authorized ROE balancing the interests of utility customers and shareholders be lower than the reasonable estimate for cost of equity under the approach that you're advocating?
Thank you. Now I understand your question. And actually, I have addressed that in my testimony. From about 1977 to about 1983, in every year, the return on equity was lower than the cost of equity for Wisconsin Electric Power Company. If we go back to my testimony, at page yes. So for example, on page 19 of my direct, the commission set the ROE at 14.5. And if you look on page 18, the cost of equity was about 18%, and that continued for about a decade. So it's certainly not only possible, it actually happened. And it was happening across the entire industry. Now, I do not think that is actually a desirable situation. I actually don't think it's even fair. The Cubs position is that the bottom is the cost of equity. But what was happening, as I covered in this testimony, is that the commission found that it just could not set rates high enough to cover the cost of service, including the fair or even the minimum cost of equity. So long answer to your question is yes, it could and it did.
To your knowledge, since the mid 80s, has a commission done that?
Set it below. I know that a commission, at least one, has tried to drive it to that level. I do not know of any that that have set it below a cost of equity estimate.
Switching topics, are you familiar with the discovery requests that WPSC served on Cub on September 14th?
Were those the discovery asking for my research papers and things of that nature?
Yes.
Yes, I'm familiar with that.
And as you mentioned, several of those requests asked for articles, research papers you'd written over the years, right?
That was among the items that were requested, yes.
Are you aware that on September 27, Cub responded to those discovery requests, but mostly through objections?
I'm not sure. I know that we objected to most of them. I don't know what date we responded.
Your Honor, yesterday with our disclosure email, I had circulated a copy of Cub's responses to Cub's September 27 responses to the WPSC discovery. I'd like to talk about that and enter it as an exhibit.
Okay, just a minute. Let's go off the record. Was that an email from you, Attorney Wilson?
Yes.
Seeing your email for tomorrow's hearing, but not for yesterday.
I sent it at 1:22 yesterday.
Can you send it to me again? It's not showing up. Or if anyone has that email, can they forward it? How about Attorney Bedford? Any chance you may see it?
I just sent it, Your Honor.
You did. Okay. All right. Well, I have IRF here. Is there any, do we have a, oh, there we go. Okay, so this is meant to be, it's not meant to be an exhibit at this time.
Yeah, I can lay foundation for it.
Okay, is this what we're looking at, what we were looking for?
Yes.
Familiar? Yeah, okay. All right, go ahead. Back on the record.
Thanks. Dr. Keim, does the document that you're looking at look familiar to you as Cubs September 27 objections and responses to applicants' first set of discovery requests?
It does, but Your Honor, could we scroll down just a little, just so I can see the objection to the first objection as we have stated it?
The from a particular, not the general ones.
Yeah, not the general ones, the actual specific. That'll, okay, let me, yes, that appears to be our response, or our objection rather.
Your Honor, I'd ask that this exhibit be added to the record as Keim 8. Please.
Keim 8. All right, any objections? And is this the extent of the response, or are there other?
Yeah, there was a supplemental response, but I'll get to that in a second.
Okay, all right. Okay, any objections to receiving that as Keim 8? That's our next one, right? Yes, okay. All right, we'll put that in.
Dr. Keim, were you involved in helping to draft the responses shown in Keim 8?
Yeah, yes, I worked with Ms. Ferris on that.
Okay. Is it your understanding that when the responses in Keim 8 were provided, no documents were provided?
So just to be clear, you asked me when this document that's on the screen, the objection, we did not in addition provide documents. Is that what you're asking me?
Correct.
Yes, we did not. This is just the objections.
You did produce some documents yesterday afternoon in response, correct?
I produced some documents. I'm not sure when they were provided to you. It could have been yesterday afternoon. I'm not sure.
When did you provide them for their production?
They were being produced starting, I think there were 76 articles and worksheets, and they were being produced starting last week. And then I guess there were some of them we were trying to figure out how to transfer the file. So that would have been yet. If you're saying you got it yesterday afternoon, that would make sense.
Yeah, but you started to provide them last week.
Well, we started to assemble. It's a massive amount of, we created a file for all of the articles, and we started putting the files in a folder. But yeah, at the end of last week is my recollection.
You referenced 76 documents, is that right?
Yes, that's my recollection. There were 76 articles, and then also a spreadsheet.
Are you aware that those 76 articles, when compiled totaled over 170 megabytes of information.
I am not, I don't know. I don't know whether,
Of the 76 articles and materials you provided, some of them date back quite a period of time, up to a decade or more, right?
yes.
Were those all in your possession, or did you go out and gather them in response to the discovery request?
I think only two I could not find that I had copies of their articles, one of which I had written, and one other one that I've used extensively that I could not find. If you want me to identify those for you, I will.
Yeah, please do.
So the two that I could not find were my article on the superiority of spot yields as interest rate forecast in Fortnightly magazine. And that's a 1996 article. And then a 1994 article by Myers, Myers, and Borucki, Borucki. I had all the others, but I did not have those two.
So when you say you had all the others, you had them in your possession as of September 14th?
I have a research library file.
One of the articles that you provided yesterday afternoon was an article you'd written for Fortnightly in 2011 called Rethinking ROE, right?
That's correct.
And Your Honor, I had sent that to the group this morning since we didn't receive it until yesterday afternoon. I noticed that yesterday I had responded to someone else's notification email, and you may not be on there. So I apologize for that. If I could, I'd like to forward that email to you from this morning.
Yeah, go ahead.
While we're waiting for that to come through, Dr. Keim, we can start to lay the foundation for it. It was the response to one WPSC RFP4, and it's a copy of the article titled Rethinking ROE, if you recall that.
Yes.
And the copy of that article you provided is accurate and complete to the best of your knowledge?
Yes.
Your Honor, I'd like to have that article entered into the record, please, as kind 9.
Okay, I'm just looking for that here. So the Earth version, oh my God, yours. So that's the version of Earth. I'm assuming it's.
Yeah, it's the same thing.
Okay. All right, any objections? Okay, that'll be time 9. Okay, go ahead.
Thank you. Dr. Keim, can you explain why the 70 plus articles that were in your possession as of September 14 were not provided to the applicants in response to discovery until literally the eve of the hearing, given their volume and the date of the discovery request?
We responded in a batch.
Well, I know that, but they were all in your possession. Why couldn't they have been provided earlier than the eve of the hearing.
We responded in keeping with procedures for discovery.
Are you aware that when the applicant sent that discovery request, they said, in light of the schedule in this case, we request production no later than last Friday?
I believe that's in the request.
Is there a reason that you couldn't produce these documents that have been in your possession the entire time by at least last Friday?
Yes, because I was working on the other aspects of this case.
Are you aware that the request asked that they be provided on a rolling basis as they were available?
That I do not recall.
Objection, Your Honor. These questions have been asked and answered, and Dr. Khan was actually he was actually hospitalized last week, and in an effort to provide to go above and beyond in terms of providing information that was relevant or that applicants sought to review, Dr. Khan pulled documents from various collections, including some hard copies, and he was simply hospitalized last week, and we were not able to complete this before the time that we did, and we went through extraordinary efforts to compile these 76 documents.
I'm just wondering what the point of all of this is. If you want these documents on the record, they'll be on the record. What I'm seeing in front of me here is a published article. It's available in other ways as well. And I know typically respondents to discovery will respond by saying some of the information is available publicly. Where are we going with this?
Well, obviously I was not aware that Dr. Khan was hospitalized last week. I'm sorry to hear that.
Thank you.
We got 170 megabytes of documents dumped on us at 3:00 yesterday afternoon. We have not had a chance to even begin to scratch the surface on digesting them, weighing whether they might be relevant in the case. I'd ask that when we do have that opportunity, we'd be allowed to submit a delayed exhibit or at least an offer of proof on them if we feel that's warranted.
Well, I don't think that is warranted. That may delay review of the record in this case. And so you'll have to make a decision whether that's to your best interests. I mean, the way I see, I mean, the party responded, you have the documents. The timing is not conducive. We're all dealing with those time constraints in this case. And it's just something we're gonna have to live with.
Dr. Keim, one last question on this issue. One of the things that was provided yesterday was your work papers, right?
Correct.
And those work papers existed at least as of July 15th, supporting your initial analysis, right?
Well, that's an ongoing basis that was all the way up to my server rebuttal. It was being updated.
Yeah, that's right. The work paper support direct testimony existed as of July 15th, right?
Yes, it's one big work paper, but that portion, those tabs would have been in existence earlier.
Yeah. All right. Would you agree that a firm's cost of equity is ultimately set by the investors who make a decision to invest in the firm?
It's made by the trades of large institutional investors, some who are buying, some who are selling, and it's not necessarily investing in the firm. They're selling and buying the security. So I think your definition is incomplete.
Would you agree that the firm's cost of equity is ultimately set by the investors who make decisions to invest in the equity of the firm or invest in the securities of the firm?
Okay, and Your Honor, I need that one read back so I can get the detail.
Okay, go ahead. We can read that back.
Question, would you agree that the firm's cost of equity is ultimately set by the investors who make decisions to invest in the equity of the firm or invest in the securities of the firm?
Not quite. If you would have stopped with or invest in the, if you hadn't added or invest in the securities, because debt is a security and the cost of equity applies to the equity. So I think if you would knock off that last clause about securities, so if perhaps you could re-ask me that question, or or maybe you have an answer from me, but it's securities is too broad because debt is a security and cost of equity doesn't have anything to do with the debt.
Fair point. I'll re-ask it so we have it for the record. Would you agree that a firm's cost of equity is ultimately set by the investors who make it?
I'm sorry, you broke up for me. Would you agree?
That a firm's cost of equity is ultimately set by the investors who make a decision to invest in the stock of the firm?
To either buy or sell it.
Thank you. Do investors rely at least in part on blue chip interest rate forecasts when making investment decisions?
I don't know. I hope not, because they're terribly inaccurate.
Do you really think that institutional investors don't make investment decisions based on blue chip forecasts of interest rates?
Absolutely, they do not. If you look at the literature, they know that that is a fool's errand. If you look at like the Yale endowment, they never use interest rate forecasts. The successful investors, if you look at Larry Swedroe, S-W-E-D-R-O, S-W-E-D-R-O-E. He's a portfolio manager who's a successful one. He overtly says you should never use them. I'm trying to remember the name of the successful Yale endowment manager who says never use forecasts. Anybody who's trained in finance would know not to use them. So if somebody is using them, they're just making a mistake.
You've identified two equity investors who you claim do not rely on blue chip interest rate forecasts. Are you saying that there are not institutional investors out there who rely on that widely cited and used forecast of interest rates?
I don't know.
I'm sorry, widely cited and used forecast
of interest rates.
Thank you.
No, I don't know that anybody would use them. That's not what those forecasts are used for.
Could you take a look at page 2 of your rebuttal testimony?
Bear with me for a second here. Rebuttal, you said?
Yes.
Okay. I'm there.
Okay, specifically lines 16 through 20, and I'll give you a moment to read that.
I've read it.
At those lines, you advocate for the use of spot estimates to forecast future dividend yields and interest rates, right?
Correct.
Those qualities of spot estimate are true only for the day that is picked for the estimate, right?
I don't understand your question.
Well, those spot estimates are only accurate on the day that the spot estimate is made, right?
They're the most accurate forecast of future interest rates and dividend yields on that day. And then when we move one more day forward, then we have new most accurate. Am I answering your question?
Yes.
Yes.
So I think you said the very next day, the spot estimate will change and the prior spot estimate will no longer be accurate, correct?
It will not be as accurate as the new spot.
Okay. Sometimes volatility in a market can result in a significant change in spot estimate, even from one day to the next, right?
That's correct.
In fact, the spot estimates used in your original DCF analysis from July 15 are no longer accurate, are they?
They're not the best estimates.
And this is shown by the results based on spot estimates from your September 26th testimony. There, your DCF results, which estimate the cost of equity went from a range of 6 to 7% to a range of 6.3 to 7.8% over the course of 2.5 months, right?
I don't think that question's correct because I think you just mentioned the DCF model. The range of my estimates is DCF and CAPM.
Okay.
So if your question is, or maybe I should have let you ask the question.
Sure. Your estimate of cost of equity has gone from 6 to 7% on July 15 to 6.3 to 7.8% in 2.5 months, right?
If we're going to drill down to the detail, I show the detailed number. 6 to 7 is my sort of summary, but I actually have the detail of it went from 6.2 to 7.2. In the original was 6.2 to 7.2, and then the new was 6.3 to 7.8. I don't know if that was clear.
Oh, that's clear.
Okay.
Let's look at page 7 of your rebuttal testimony. Despite your estimate of the cost of equity increasing over the last 2.5 months, am I reading your testimony at lines 13 to 15 to say that this is not evidence that the utilities cost of equity is rising?
If you read the entire sentence, we cannot conclude that the cost of equity is rising as we look forward. There's no evidence that it's rising.
Is there evidence that it's falling?
There's no evidence of any direction, and with the spot random walk, there never is.
You have no idea what the spot estimate would be on whatever day in November or December that the commission is deciding this case, do you?
No, but I think the commission should use the latest spot on that day. In fact, when I was on the staff, I developed the procedure in which a update was provided to the commission as close to the decision as possible, and I would support that very same process.
Directionally, do you anticipate that the spot estimate will be higher on that day or lower on that day than today?
No,
You don't estimate.
we don't ever, if you're a good financial economist, you would never predict interest rates or stock prices. It's just, you're going to be inaccurate. If we understand the way, it's what's called the martingale process. It's always the best estimate is your spot, and you do not forecast up or down.
At pages 12 and 13 of your rebuttal, you discuss a example involving Alcoa. Do you recall that?
Yes, I do.
Okay.
I will add that I actually had some errata on that. I had some labeling incorrect.
Okay. At the top of page 13, you analogize the stock price of Alcoa at the time to what it would equate for WEC stock price today, right? And you say that the Alcoa stock price at that time would equate to $12 per share for WEC today.
Correct.
What would be the consequences to Wisconsin Electric if WEC Energy Group's stock price was slashed from $90-ish today to $12, in your opinion?
Well, that is the consequence. Investors would have suffered existing investors would have suffered massive losses as the stock resettled in at the point where it could raise capital from new providers.
Would you anticipate a credit downgrade as a result of that sort of decline in stock price?
Absolutely.
Would you expect that the company would experience an increased cost of debt as a result of the credit downgrade and or the reduction in stock price?
It would experience an increased cost of debt, an increased cost of equity, but not necessarily an increased cost of capital.
Is it safe to say that in that scenario, new investors would gain at the expense of existing investors?
Well, the new investors always get the same return, but it would be taken out of the hide of the existing investors. That it would get priced so that they would get the new investors will get the cost of equity, whatever that is. But the fall from say $96 a share to $12 a share would be borne by the existing investors.
So that's a yes.
Well, I guess I'm not sure what your question was. I'm sorry.
Could you read the question back, please?
Sure, go ahead.
Caught me with dogs barking. Question, is it safe that in that area, new investors would gain at the expense of existing investors?
No, they don't gain. They get the same return at 96 or at 12. The new investors, because the ROE would have changed dramatically, and it just gets repriced to produce the same return. So there's a value loss for the existing investors, but it just gets repriced to produce the same cost of equity.
Are you familiar with Mr. Singletary's rebuttal testimony?
Yes, I've read it.
Okay. At page 13 of Mr. Singletary's rebuttal, he talked about a 2007 decision involving.
I'm sorry, I don't have that in front of me, or Your Honor, if you could put it up for me. Thank you.
Off the record, where are we going? Direct?
Mr. Singletary's rebuttal.
Sir, okay. You know, are you switching topic at all?
Yeah, I'm switching topics right now.
I just got a follow-up from where we were headed in the last question. I just wanted to interject with the scenario that's set up by
Are you on or off?
on the record, yeah.
Thank you.
Sorry about that. Yeah. So the scenario that's set up in your we're just discussing with Attorney Wilson, share price dropping for WEC to $12 per share. And you stated a loss of value for existing shareholders. Would you classify those as unrealized losses?
Well, to use a financial economist frame, realized or unrealized is an accounting transaction, whether they actually sold or not. The loss is there. It's a real loss, whether you sell or not. It's a loss. So, are you asking me? Did they to know whether it's realized or unrealized? I would have to know whether they sold the stock. And from an economics point of view, it doesn't matter. So I don't really know how to answer your question. It's the same whether you sell it or not. You've lost the money.
Okay. That's bad news for all of us at this time of the economy. But anyway, so could you tell us if there's a prediction about what the dividend would look like in this situation?
I couldn't tell you. We'd have to work through the fundamental drivers, which would be return on equity, retention rates, all of the drivers, margins, all of that stuff. But if you're asking me, could the dividend change? The answer is yes, it could change. I can't tell you what it would be.
Okay. So okay, we'll leave it at that. Okay, great. That's fine. So let's move on to Singletary. What page were we going to be?
13.
Okay. We're ready.
So, Dr. Keim, this discusses a 2007 commission decision involving MG&E. Are you familiar with that?
Yes.
And Mr. Singletary cites this decision as an example of where the commission explicitly took the approach that you're proposing in this case, i.e. establishing cost of equity and then applying a premium to reach authorized return on equity, right?
Correct.
Were you a member of commission staff when this decision was issued?
Yes, I worked on this case.
Okay. And were you the staff witness on ROE in this case?
I was.
Did you draft the ROE section of this decision?
I prepared a draft. The drafts get edited substantially. I probably penned the original draft.
Okay. You have any recollection for how much authorship you could claim for this excerpt in Mr. Singletary's testimony?
It's conceptually close to the testimony that I gave in the case. I don't know about the words per se, but it's on track.
Okay. Do you recall that in this case, the commission agreed with staff's, and I guess it'd be your approach, which included consideration of DCF, CAPM, and risk premium models?
I don't remember the models, but the commission looked at models.
Okay. And did you have a preferred risk premium model at that time?
I don't recall the details of the analysis. It's 22 or it's 15 years ago. I don't remember.
Can you cite any commission decisions since this 2007 MGE decision, which applied in this explicit way the approach that you're advocating in this case?
Not in an explicit way.
Nothing further.
Okay. Other cross? Nobody? All right. How about redirect?
No redirect, Your Honor.
I guess I do probably want to ask the question following up from the last one. If you recall, witness Kime, whether the commission followed the policy stated in 3270 UR 105 with respect to ROE in subsequent cases. Did it apply that policy without being as explicit in its statement of the policy?
First of all, just for technical correction, the docket number 3270 UR 115 is correct in the site, but it's cited as 105 but so it's 115, not 105. That's an error on our part. I know that the commission embraced this approach. I know that everybody, including the utility in the case, embraced this approach. So there's unanimous support for it. I don't recall what happened now than 14 years ago, that happened in the next years. I don't recall.
Okay, that's fine. All right, any redirect?
No redirect.
Okay, great. All right, thanks, you're excused. Ready for witness Singletary? He's sharing.
Oh, excuse me. Cub calls Mr. Corey Singletary. We might need just a moment here to switch up our mics.
All right, that's good. Let's swear you in. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Please spell your name for the record.
Corey Singletary, CoreySingletary.
And Mr. Singletary, did you prepare and cause to be filed or file in this proceeding direct, rebuttal, SIR rebuttal testimony, 6 accompanying exhibits, and errata for direct and SIR, and 2 replacement exhibits.
I did.
And inclusive of that errata and the updates in the offered evidence list, is that testimony and the information in those exhibits true and correct to the best of your knowledge?
It is.
Do you have anything to add to your testimony at this time?
I have a brief response to commission staff's SIR rebuttal. In SIR rebuttal, Mr. Mellemans indicates that he read my rebuttal testimony as suggesting that he disregard or downweight the results of certain cost of service study methods when developing a revenue requirement or rate proposal. It appears that Mr. Mellemans interpreted my rebuttal as attacking his work specifically. If this is how Mr. Mellemans interpreted my rebuttal testimony in this way, I wanted to say that that was my intent. I have the utmost respect for commission staff and the work they do, particularly given the constraints currently placed on them and how they go about doing their job. But Mr. Mellemans' SIR rebuttal does illustrate that perhaps I need to clarify the point I was attempting to make in my rebuttal testimony. As I have noted in my testimony, I believe that the rate design process from cost allocation all the way down to the development of tariffed rates requires the application of judgment on the part of the commission as well as the rate analyst. Others may disagree with me, but that's what my position is. In discussing the constraints placed on commission rate analyst staff, my goal was simply to highlight that this element, the use of informed judgment, is not, and indeed consistent with Mr. Mellemans' testimony, cannot be reflected in Mr. Mellemans' revenue allocation proposal. As such, as I discussed in my rebuttal testimony, his proposal should be viewed within those constraints. Additionally, as Mr. Mellemans is precluded from arriving at any conclusions regarding the methods used in any one cost of service study or another, or even simply providing his informed, objective, professional opinion regarding the different cost allocation methods, his testimony should not be used to arrive at any conclusions regarding the strengths or weakness of any one cost of service study.
Okay. And do you have any further responses to the SIR rebuttal that was filed this morning?
Not at this time.
Your Honor, Mr. Singletary is available for questions.
Okay. So I just want to clarify first, I saw you had 2 erratas for direct. Are they additional? Do they add on to each other?
They are cumulative. So the revised is a rolling, so it includes everything that came before. That's how I interpreted the facilitating matters, at least in terms of numbering convention.
Okay. All right. I'm glad I asked. I'm not going to give you any advice on that. So do we have cross for Singletary?
Yes, Your Honor.
Okay, can I just ask my general question first? I think it's just a general one, right? All right, so I was directed to ask you the general question about Cub's position on those various items. So let's try it out again. To the extent that Cub has a preference for the following, state it and cite to where it appears in the record. If you want to just go through them one at a time: revenue requirement, E-cost, G-cost, revenue allocation, cost of return on equity. I believe those are the ones that you can address.
Yes. With revenue requirement, I believe consistent with the discussion this morning, I think it might have been off the record in terms of facilitating matters as it relates to the settlement. Cub supports what's sort of reflected there as it relates to revenue requirement, but insofar as separate from that, we do not have a position. Insofar as electric cost of service study, consistent with my direct testimony, if you'd like, I can find you a specific reference, but in my direct testimony, the Cub's preference on electric cost allocation or costs is would be what's referred to as method 6. I believe it's 12 CP capacity basic customer method. Insofar as gas cost of service, between the two, cost of service A and cost of service B. Cub's preference would be for cost of service B. And insofar, I think that's, was there anything else? Were you asking for position on revenue allocation as well?
Yes.
Okay. For revenue allocation, for Wisconsin Public Service Electric, CUB supports the company's originally filed electric revenue allocation, or one that is generally consistent with that, taking into account that final revenue requirement may differ from what was filed at that time. And then for natural gas cost revenue allocation, we would support commission staff's natural gas revenue allocation for Wisconsin Public Service.
Okay.
And then the last question, I believe, was on cost of equity, return on equity. And consistent with what Dr. Keim had just said, you know, I testified and he testified originally that CUB's original recommendation with respect to an authorized return on equity for Wisconsin Public Service be set at 9.0%. In responding to Ms. Bulkley's rebuttal testimony, and, you know, consistent with the framework that CUB is advocating for here, you know, we would be willing to accept a 9.1 if the commission believed that the performance differential between We Energies and Wisconsin Public Service, you know, warranted that differential treatment. So 9 to 9.1, depending on what the commission decides.
Okay. All right, great, thanks. All right, so I'll turn it over to Attorney Wilson for cross.
Thank you. Good afternoon, Mr. Singletary.
Good afternoon.
You're on staff of the commission from 2010 through 2017, right?
That is correct.
In your direct testimony at pages 1 and 2, you describe your duties during that time, right?
That sounds correct, yes.
It doesn't appear that you had any responsibility for cost of equity or ROE in your time of the commission, right?
I did not.
And you've worked at CUB for the last 5 years, right?
Sorry, I have to check the math. It feels like dog years. I
know the feeling.
Yes, that's true. Yes, that's correct.
Okay. And in that time, have you provided testimony on cost of equity?
I have not provided expert witness testimony in a proceeding. I did draft CUB's position on in comments before the commission that were related to ROE reform generally, but that was not in a litigated proceeding.
Have you? Okay, so that was on ROE as opposed to cost of equity. As
correct.
Understanding those terms in this case.
Yes. Well, it was if we want to pause for a moment and talk about what, you know, I filed on CUB's behalf in that separate instance, it was discussing this whole notion of sort of, I guess, ROE reform and using the explicit framework that we're talking about here today. So cost of equity comes into it, and as does ROE. But I guess your broader question, have I been an expert witness testifying in a litigated proceeding on return on equity or cost of equity? No.
What docket is that you're referring to?
Subject to check, I believe it's 5 EI 158. I believe that the zero carbon roadmap docket, if I recall correctly.
Okay, got it. So it's safe to say this is your first foray as a testifying witness into ROE and cost of equity, right?
That would be accurate.
I just want to make sure that when I talk about CUB's approach, that you know what I'm talking about. So in your rebuttal testimony, you described CUB's approach to establishing a ROE in this case as, quote, determining a reasonable estimate of cost of equity and then setting a final authorized ROE that balances the interests of utility customers and shareholders. Is that right?
I believe that would be the most recent description I have of that process. Yes.
Okay. So when I say Cub's approach, that's what I mean, okay? Under Cub's approach, can you provide any sort of formula that would tell the commission how much of a premium to award over the cost of equity when establishing authorized return on equity?
No, that runs counter to our testimony that there is no formula for ROE at.
So then how are they supposed to decide?
That is for the commission to decide. I mean, if I can be casual here for a second, that's why the commission gets paid the big bucks to make the big calls on public policy issues like return on equity. To say that it comes down to a formula not only flies in the face of the Supreme Court's decisions on just and reasonable, but also does a disservice to what the commission's job is, to actually determine what just and reasonable is, not just be wedded to the results of a model output.
You, in your testimony and in materials cited in your testimony, refer to a number of factors the commission might consider when deciding on the amount of premium over cost of equity. Is that right?
Yes.
Okay. So as I said in your direct testimony, there's a number of performance metrics, right?
In my direct testimony, I kind of explore 3 specifically, but I do list a number that the commission could consider.
Okay. And are you aware that there are some metrics identified in the 2007 MG&E decision, which you cite in your rebuttal testimony?
I would have to go back and check that the specific order.
You don't purport to have identified a full universe of metrics the commission might weigh in deciding how much of a premium to award, do you?
No, I explicitly state that I have not in my direct testimony.
If the commission were to adopt this approach as a policy matter, would the metrics be the same for each of the investor-owned utilities in Wisconsin?
I think it would be reasonable that they would be.
Would the metrics change from case to case?
That would be up for the commission to decide. I think my sense there would probably be, and I think it would make sense that there would be, a sort of a core set of metrics. But the commission, in exercising, more of its sort of policymaking powers, could change sort of what's important over time, because certainly the industry changes over time. But I think it would be only fair to the companies that if the commission wanted to make such a change, that the utilities be, made aware of essentially the measuring stick they're going to be measured against in advance.
Okay. Well, if the commission adopted your approach in this case, the utilities would not have been made aware of those metrics in advance, would they?
They would not. But at the same time, the company has, as I've testified extensively, the company really hasn't provided any, testimony, that's related to, for example, the balance of customer and shareholder interests, or any of these, or entertaining any of these factors. So, absent that evidence, consistent with what I've already testified to, that Cub's position is that we should move in the direction of the cost of equity, absent some evidence that we should be doing something else.
So is your testimony that your testimony provides adequate notice to the utilities that their ROE will be established based on the metrics set forth in your testimony? I'm not.
No. My testimony is that the company hasn't provided any testimony as to why they are deserving of an authorized ROE in excess of the estimated cost of equity, to the extent that their proposed ROE is in excess of the cost of equity. And so I believe that going forward, it would be beneficial to all parties, Cub, the utilities, and everyone, if we kind of had a better roadmap. But for the purposes of today, that's where we are.
So you're not suggesting that the commission adopt your approach in this case. You're suggesting that the commission put the utilities on notice that it may adopt this approach in future cases. Is that right?
No, that's not what I'm saying. I'm saying that as Dr. Keim and I have testified, this framework has existed for decades. This is not new. This is standard corporate finance. This is consistent with the fair and reasonable standard for ROE. And so the company, in preparing its filing, had the burden of proof to demonstrate why its requested ROE of 10.0 satisfied all the requirements for the commission to bless it, to authorize that. And we think that, consistent with the absence of any evidence, from our perspective, that would support the premium over the cost of equity embodied within the company's request, that there be a meaningful movement towards the cost of equity in going from 10.0 to 9.0%. And that if the commission wanted to, for the future, put the companies on notice as these are the things that we will be explicitly evaluating. When I say we, I mean the commission, the things that the commission will be explicitly evaluating, that it would be reasonable for it to do it here. Or the commission could convene a separate set of workshops or investigation to set that framework more explicitly. But in terms of how you can get from a 10 to 9, it doesn't require really anything other than just an examination of the evidence is there. And, we also took into consideration things like, the revenue requirement impact to customers, during this particular period, and the meaningful impact on rate relief that a 10 to a 9% change on ROE would make.
Is it your understanding that Dr. Keim's estimates of the cost of equity, which have varied in this case, represent a floor for ROE, but that an authorized ROE at that level would not be appropriate?
Yeah, that's CUB's general position, is when the commission determines what a reasonable estimate of the cost of equity is based off the evidence in the record, and there's a range of cost of equity estimates in this record, that once the commission determines what a reasonable cost of equity is, then yes, it's CUB's position that is the floor, as it were, right? And that it build from there.
Right. And a return of equity set at the level of cost of equity would be unreasonable, correct?
It is CUB's position that is not the goal. Right. The goal is not to align ROE with cost of equity.
CUB is recommending a move from 10% ROE to 9 or 9.1% ROE in this case, right?
Correct.
And you've expressed that is CUB's view of taking a gradual approach. Is that right?
Yes.
Can you point to any other examples of the commission reducing a utility's ROE by 100 basis points in one case and in the interest of gradualism?
I cannot.
If CUB's estimated cost of equity in this proceeding is 6.2% or 6.8% or 7.2% or 7.8%, what is the ultimate ROE that CUB believes is appropriate for the company?
As we sit here today with the particular set of information before us, I can't give you a specific number. I mean, that's ultimately for the commission to decide. It's CUB's position that again, with the evidence before us, that it should be closer to, say, a range of 6.3 to 7.8, which is Dr. Keim's most recent cost of equity estimate, that it should be closer to that than certainly what the applicants have proposed in their filing.
Wouldn't knowing CUB's proposed final destination for ROE help the commission, quote unquote, drive toward whatever that number may be?
It would having a target is certainly always helpful. Regrettably, we can't provide that information here. All right.
Well, you could, but you're choosing not to, correct?
I don't, where Cub is today is, again, the ROE of 10.0, we don't believe is supportable by the estimates of cost of equity and also any, again, evidence that would support the premium above that. We don't have a target because what we are arguing for is that we should have more of an explicit framework for what is important to the commission when it weighs whether the interests of customers and shareholders are fairly balanced. And even just a list of criteria that we could consider subjectively would put us much closer to figuring out, kind of where we're headed. Cub's position is not, let's say, for example, that if you want to use a point estimate of cost of equity, that it's 7, let's use 7 for a number. All right. It's not, Cub's position is not that it should be 7, barring any evidence to the contrary that the company has earned something, has earned a significant premium above that, something a little above 7 would probably be reasonable. But to provide a destination for the commission when ultimately it's for the commission to determine is not what we're doing here in this proceeding.
I mean, you've provided a recommended ROE. You're not hesitant to provide suggestions about where the commission ought to go, but you're unwilling to provide a suggested final destination for ROE. Is that right?
Well, the 9% or 9.1, we'll call it a 9 for the sake of argument. It's a nice number. The 9 is directionally consistent with what we believe is reasonable. All right. And when I say that is certainly we could have proposed something lower than 9. But because we're in the interest of gradualism, we're going to say we're going to stop at 9. We're not, so if you want an answer to my question, the ultimate destination for the commission is lower than 9. Again, barring any fact-specific evidence for Wisconsin Public Service that they have earned something else. Right.
Nothing further.
You're muted, Mike.
Okay, there we go. Any other cross?
Your Honor, Commissioner Huebner has a question.
I see that. Go ahead.
Yeah, hi, Mr. Singletary. Can you hear me?
I can.
This is Commissioner Tyler Huebner. In the discussion that you just had with Mr. Wilson, there was a discussion about Cub's position of an ROE of 9.1%. And please, if this is in the record, my apologies, but just to clarify, has Cub produced the number of what the revenue requirement reduction would be if the ROE was changed from what was proposed to Cub's recommended 9.1%?
Oh, you're catching me off guard here. I think if I recall correctly, and this is subject to check because this is based off of conversations Dr. Keim and I had several weeks ago in terms of framing what was going to go into the testimony. If I recall correctly, I thought he put for the 9, I thought he put it in his direct, but that may not be correct. I don't know. The honest answer is, as I sit here today, I cannot recall if that specific valuation is in the record in this proceeding.
Maybe I can ask just a second question that might help me directionally understand. So Walmart's witness Kronauer estimates going from a 10% ROE to 9.59 would be about $10.7 million of savings. So a 0.4% reduction would be about 10.7 million. Would you just kind of expect that to be linear? If you continue to go down another 0.4, it would be approximately another 10.7 million.
For
and that could be roughly. You know, is that,
Yeah,
is that a linear relationship? Thank you.
Yeah, assuming that calculation is correct, Mr. Cronauer's estimate is correct, which I'm not in a position to dispute it, but we'll just caveat that. Then typically often in conversations in these rate case proceedings, we use that kind of shorthand rubric where we say 10% basis, 10 basis points equals X millions of dollars. And so to your question, it is essentially linear, as you could extrapolate that out. Yes.
Okay. Thank you.
All right, any other cross? No, all right, so redirect.
No redirect.
All right, great. Thank you very much. You're excused.
Thank you.
Let's go off the record. So we're looking at IUOE. That party's still not in appearance, right? I don't know exactly what to make of that. Okay, so let's get on the record. So it is time to call witness Tesla from party IUOE. I don't see that party in attendance. So without having the party available for either questions or verification of the testimony, I'm going to leave that testimony out of the record. So let's proceed.
Your Honor, I'm sorry. If it's helpful, that's obviously the company's union. We could reach out to him. He may just not have realized that he needed to be here to verify it. But don't help.
You can't help with that. I'm sorry.
Can't help with that.
You can't help with that. No, that's an obligation of a party to be in attendance, present its witnesses for testimony verification. So there's nothing we can do at this point. Okay, so let's move to, so Renew we have, Walmart, we've taken those witnesses. So we have WIG next.
Your Honor, this is Cindy Smith from Commission staff. We are starting to hear from some staff that are going to run in, given the lateness of the day, with some scheduling issues. Would it be possible perhaps to take some of the commission staff, at least one or two that are having these conflicts, out of order, please?
Sure, that's fine.
Ms. Bedford, if you want to proceed, I believe it is witness Adams that needs a special dispensation here.
Yes, that's correct. Stephanie Bedford appearing for the PSC. The commission calls Justin Adams to the stand.
Okay, see you there.
Can you hear me?
Yes. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Justin Adams.
And what is your position at the Public Service Commission of Wisconsin?
I am a financial analyst.
Did you cause or file or cause to be filed surrebuttal testimony in this docket?
I did.
Did you file or cause to be filed direct testimony in this docket?
I did as well.
Did you also file or cause to be filed 2 exhibits?
I did.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
They are.
Do you have any additions or modifications to your testimony or exhibits at this time?
I do not.
Your Honor, the witness is available for cross.
Okay, do we have any questions for the witness? Seeing none, you're excused. Thanks very much.
Thank you.
Anyone else?
That's the only witness we have that I know of who had a time constraint.
Okay, so let's move on with WIG. Call your first witness.
Sure, thank you, Your Honor. I'd like to call Mr. Bauer to the stand, please.
Okay, we're just gonna go off the record for just a second. I have a annoying cat that's trying to become part of the hearing. Okay. Thanks for that. So we have, oh, where's the screen? Okay, can Witness Bauer turn his screen on? There we go. Great. Okay, see you there. All set to go?
Yes, I am, Your Honor.
Okay, great. Let me swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Thank you. Good afternoon, Mr. Bauer. Could you?
Good afternoon.
Thank you. Yes. Could you please state your name for the record?
My name is Robert C. Bauer, B-A-U-E-R.
Mr. Bauer, did you prepare and cause to be filed direct rebuttal and surrebuttal testimony and one exhibit?
Yes, I did.
And is your testimony and the exhibit true and correct?
Yes, it is.
If I were to ask you the questions set forth in your pre-filed testimony today while you are under oath, would your answers remain as you provided in the testimony?
Yes, they would.
Okay. Your Honor, Mr. Bauer is available for questions.
Okay, any cross? No, all right, I have my question for you. So in terms of gas service, I believe you can speak to, what extent does WIG have a preference for the following, and where does it appear on the record? And that's revenue requirement, G costs, and revenue allocation.
Okay, with the revenue requirement, I have adopted the staff adjusted revenue requirement throughout my testimony and cost of service. My gas cost of service preference is the cost of service A, or base cost of service gas, or the base cost of service study, with recommendations that I set forth in my direct testimony, pages 3 to 14. The revenue allocation, I support the commission staff's revenue allocation, and I set forth that agreement in my rebuttal testimony on page 1, 3, and 4, and my surrebuttal testimony, pages 1 and 2.
All right, thanks. And I just had one specific question for you on your direct revised page 12, line 14. Use the word class 6 customer, and I'm just wondered if you had a definition for that.
The class 6 customer should be the super CGSL class that I was discussing.
Okay, that's good enough. All right, thanks. Okay, so any questions based on my line of questions? And any redirect?
No redirect, Your Honor, but in connection with the question you just asked, I know that on the document they gave us last night, the offered evidence, I think you suggested that there should be, we should refile his testimony for a couple of reasons. One of them was to define this class 6. Do you still want the testimony modified to say what that is?
No, I didn't intend to do that. So
okay.
My comment was to clarify on the record by defining the customer class. So,
okay,
so we're fine with that. Yeah. Thanks.
Okay. Thank you.
Yeah. All right. Great. You're excused. Thanks very much.
Thank you.
We will now call Ms. Kavita Maney.
There you are.
Hi.
All set. All right. We'll swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Good afternoon, Kavita. Could you please state your name for the record?
It's Kavita Maney, K as in kite, A-V-I-T-A. And the last name is Maney, M as in Michael,
Ms. Manny, did you prepare and cause to be pre-filed direct rebuttal, surrebuttal testimony, and one exhibit?
Yes, I did.
And is your testimony in the exhibit true and correct to your knowledge?
Yes, it is.
If I were to ask you the question set forth in your pre-filed testimony today while you are under oath, would your answers remain as you provided in the testimony?
Yes, they would.
Thank you. Your Honor, Ms. Maney is available for questioning.
Okay, any cross for this witness? All right, so just have my question related to electric service. To the extent that WIG has a preference for the following, state it and cite where it appears in the record. It's revenue requirement, e-cost, revenue allocation.
Okay, Your Honor, as it relates to the revenue requirement, WIG did not have a position on that. However, WIG did support the settlement. And as it relates to the class cost of service study and revenue allocation results, I adopted the staff's audit in that regard. And the citation for that is page 6 of my direct testimony. Clearly states that I used the staff's revenue requirement. And then page 7 of my direct shows WIG's preferred cost of service study method 1. Further, then with regards to the revenue allocation, that's provided in my direct testimony figure 4, which is page 14. And finally, we all expect that the revenue requirements going to change, will change because of ROE, fuel, and other issues. And so in my surrebuttal testimony on page 5, I've also recommended a proportional approach in the event the revenue requirement changes.
Okay, great, thank you.
Sure, thank you.
Any questions based on that? And any redirect?
No redirect, Your Honor. Thank you.
All right, great, thank you, you're excused.
Thanks so much.
Thank you.
All right, so I am inclined to take about a 10-minute break. Do we have any witnesses that need to go now? Can they wait a few more minutes? All right, let's just break. Let's try to be back at 4:20, 4:25.
Hey, Judge, this is Commissioner Tyler Hebner.
Yeah, we are still going live here, so.
I know. Oh, you're
Okay.
live. Okay, got it. Thanks.
You're on mute.
Oh, you're paying attention. That's what I was hoping. You came back. I thought you were going to run away.
No, I had my husband bring ibuprofen into me, so that helped. I just all of a sudden I got a really bad headache.
Oh no.
Imagine that with this on all day.
Give me a notice of that. Okay, well, we just have staff left, so hopefully we won't be much longer.
Your Honor, can I ask a question off the record about the offered evidence? So I was just, you mentioned two exhibits 4 and 5 for Dr. Kimes' rebuttal.
Okay.
So he cites on his rebuttal page 6 and rebuttal page 8.
Okay. Yeah.
You wanted us to offer those citations as exhibits, so that makes sense. But you also had a 6 there, exhibit 6, and I didn't know what that was for.
Okay.
I thought we jumped right to 7. Is there a 6 in his? Was there a?
We jump. Okay.
Because then we have his working papers that were discussed in the SIR, which we're going to provide as, we had numbered that 7, but I think it's 6.
Well, I have a 6 on the offered evidence list already. And I thought that was, so I think it's another decision, past decision.
Oh, was that the MG&E decision? Oh, no, that's not.
It's the WEPCO ER12 decision. So,
Okay.
yeah, I think he's the one citing that. I may have crossed paths with Singletary. I'm not sure.
Okay.
So.
Okay, we'll figure that out.
Yeah. So someone, we're just trying to get. The reason is those orders aren't on IRF, so
yes.
The IRF number isn't going to be able to give us a good reference. So.
Okay.
I don't see. It could be that is a Singletary exhibit instead. Yeah, if you can just figure that out. Yeah, whoever's
I'll figure it out.
Yeah, I do remember seeing it in the record. So, okay.
Thank you.
So if we've already marked, so I don't think we marked the work papers as an exhibit. Do you remember doing that? I think it was to be offered.
I think they would be offered as exhibit 7.
But did
we don't have them yet.
Right, but did we mark it as 7? That's what oh, there it is. Yeah, okay. So yeah. So just keep those the way they are.
Okay.
You need to move 6 to Singletary, just do it, and then we'll just keep Kimes 6 blank.
Okay.
So we'll have to. Okay. All right, so let's get on with staff. Thanks for raising that. Certainly are a lot of loose ends in these cases. All right, so let's have staff witnesses. Who do we want to call next?
Cade Bauer-Showers. Commission calls Cade Bauer-Showers to the stand.
Ready to go? Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
Okay, go ahead.
Please state your name for the record.
Cade Bauer-Showers.
What is your position at the Public Service Commission of Wisconsin?
I'm a utility rate analyst.
Did you file or cause to be filed direct testimony in this docket?
Yes.
Did you also file or cause to be filed an exhibit in this docket?
Yes.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits at this time?
No.
Your Honor, the witness is available for cross-examination.
Okay, any questions? Seeing none, you're excused. Thanks very much.
Thank you.
All right, the commission calls Mitchell Horry to the stand.
All right, there you are. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Please state your name for the record.
Mitchell Horry.
What is your position at the Public Service Commission of Wisconsin?
I am the Focus on Energy Performance Manager.
Did you file or cause to be filed direct testimony in this docket?
Yes.
And are the statements and representations in the testimony you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No.
Thank you. Your Honor, the witness is available for cross-examination.
Any cross? No. All right. I did have one quick question for you related to recommendations and inflation adjustments. So let me just ask those. So just wondering, did staff consider inflation when making its recommendations with respect to adjustments to the voluntary energy efficiency program budget?
No, it did not. That's not a practice that staff has typically used in these reviews.
Okay. Making that noise off the record. Is that you, Debbie?
No, I just tried
Oh.
muting and unmuting and it wasn't me.
I think it's Mitch.
I did
Oh.
the same.
Oh, did I just, I think I muted him, right? Yeah. No, where did he?
I muted myself.
Yeah, and you're making very weird noises in the background there. Sounds like a vacuum.
It's a dog ready for its afternoon walk.
Oh boy. Okay. So just one more quick question here. The same question. Did you consider inflation with respect to the proposed focus contribution budget?
No, I did not. That's a formula-based calculation determined by utility revenues, so inflation is not considered there either.
Okay, that's all I have. Thanks. Any questions? Any redirect based on that? Questions from commission staff? Redirect?
No redirect.
Okay. All right. Thanks. You're excused.
All right. The commission calls Brittany Larson to the stand.
Hi there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Brittany Larson.
What is your position at the Public Service Commission of Wisconsin?
Natural Gas Program and Policy Analyst Advanced.
Did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Any questions? No? All right. Thanks very much. You're excused.
The commission calls Tyler Mellemans to the stand.
All right. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Please state your name for the record.
Tyler Mellemans.
And what is your position at the Public Service Commission of Wisconsin?
I am a public utility financial analyst.
Did you file or cause to be filed direct
Yes.
and rebuttal testimony in this docket?
Yes, I did.
And did you also file or cause to be filed an exhibit in this docket?
Yes, I did.
And are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony or exhibit at this time?
At this time, I do not.
Your Honor, the witness is available for cross-examination.
All right, do we have questions? Okay, seeing none, you're excused. Thanks very much.
Thank you.
And the commission calls Klaus Milata to the stand.
All right, now the trouble begins. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
Please state your name for the record.
Klaus Milata,
And what is your position at the Public Service Commission of Wisconsin?
Public Utility Financial Analyst.
And did you file or cause to be filed direct testimony in this docket?
I did.
Did you also file or cause to be filed one exhibit in this docket?
I did.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony or exhibit at this time?
I do not.
Your Honor, the witness is available for cross-examination.
Okay, any questions? All right, that was easy. Thanks, you're excused.
Bye-bye.
All right, the commission calls Deborah Probst to the stand.
There you are, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay, go ahead.
Please state your name for the record.
Deborah Probst.
And what is your position at the Public Service Commission of Wisconsin?
I'm the audit supervisor.
Did you file or cause to be filed direct, rebuttal, and surrebuttal testimony in this docket?
Yes, I did.
And did you also file or cause to be filed one exhibit in this docket?
Yes.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibit at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Any questions? No, okay, I did have a couple of comment questions for you, just clarifying questions. So on direct probes 13 through 14, you talked about escrow accounting treatment for certain cost categories. And I'm just wondering, did the applicant request the escrow accounting treatment be applied in this case?
The applicant requested escrow accounting treatment for the COVID-19 costs in its application. The treatment that I proposed for the commission to consider relating to the Inflation Reduction Act and pension, that is something that staff is proposing for the commission to consider. The applicant did not explicitly ask for it.
Okay. And in terms of the distinction between escrow accounting and deferral accounting, could the commission also consider a deferral for those costs?
So the COVID amounts, the commission has already granted deferral treatment in the 5AF 105 docket. The Inflation Reduction Act component, it would be the commission could consider, and it's in the testimony, the deferral treatment, because it's costs that could occur now that would then be potentially eligible for the commission to consider recover in the next rate case. So that would be the deferral. For the pension component, escrow accounting treatment is what staff is proposing, because that would cover and account for both the market increases and decreases, so that both the applicant and the customers remain whole. And deferral treatment is normally something that is handled when it's a specific, I don't want to call it a one-time thing, but a one-time cost where they're seeking certain treatment for being handled in the next rate case. And it's a one and done item unless the applicant would request continuation of the deferral.
Okay. All right. Well, thanks for clarifying that. So any questions based on that? All right. There you go. You're excused. Thanks very much.
Your Honor, can we go off the record for a moment?
Sure.
Our last witness has a modification that he wants to make to some confidential testimony that we'd like to do in camera. So how would you like us to handle that?
Okay, well, why don't we get him on the record and get going with that presentation, and then we'll just jump into closed when it's time to do that.
Okay.
Yeah, I should have said the trouble is coming now, not with Klaus. Should have known.
Fair enough.
We saved it for last.
Makes sense to me. All right, so let's get him started here. So raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Okay, please state your name for the record.
Michael Ritzema,
And what is your position at the Public Service Commission of Wisconsin?
Public Utility Auditor Principal.
And did you file or cause to be filed testimony in this docket?
Yes.
And did you also file or cause to be filed exhibits in this docket?
Yes, 2 exhibits.
And are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Subject to the corrections that I'll be making next.
Okay. Do you have any additions or modifications to your testimony or exhibits at this time?
Sorry, just a minute. Yes, I do. On first of all, for on the public side, after listening to Ms. Keller's or seeing Ms. Keller's certiorari rebuttal, I'm not confident of my calculation in Exhibit 1 for the of the 1.9 gigawatts associated with delayed retirements. She indicated that at least for South Oak Creek 5 and 6, that those should not have been added back. So at this point, I'm not sure about the others. So what I would like to do is just withdraw from strike from my Exhibit 1 the calculation of the 1.9 gigawatt hours.
Okay, so we'll be getting a revised exhibit then?
Yes, yes. And then for my testimony, and this is for public. I'd like to strike the last 3 words of page 2, line 21, and then all of page 2, line 22 through page 3, line 7.
Okay.
And again, I'll be filing this as corrected or revised. Then to carry through the removal of the 1.9 gigawatts for purposes of my written testimony on page 3, line 9. Sorry. I turned it off before. Sorry for the interruption. All right, so page 3, line 9, 104.9 gigawatts should be 103.0 gigawatts.
So Mike, I'm gonna interrupt you for a second. I just want to make sure when we get to the point where you're suggesting changes to your confidential testimony, we will need to go in camera for that. So
yes, I will stop before.
Okay, I just want to make sure.
Yes. I have that written down as a confidential correction, so I won't forget.
Great.
All right, so page 3, line 10, 3.1 gigawatts should be 1.2 gigawatt. And for page 3, line 12, 3.0% should be 1.2%. And so with that revision, the difference between my estimate of the excess capacity is 1.2 gigawatts versus Ms. Keller's gigawatts. And based on that, Ms. Keller provided 2 recommendations for capacity values for June through August. She recommended $82.19 per megawatt day. And then for September through December, she recommended $24.16 per megawatt day. And I believe that those values are not inappropriate.
Thank you.
Then next, on page 5 of my public, line 8, where it says, line 8 starts, provide the impacts, and then insert on energy related fuel costs, and then the next word being of. And that's it for my corrections in public.
Okay.
Thank you. And do you have any modifications to make to your confidential rebuttal testimony?
Yes, I do. I have one.
Okay, Your Honor, may we provide those in camera?
Yes, we may. So let's move into closed session. I will put us into the break room, whatever we call it. And so we will disassociate from the live stream. Let's create that. I can recreate a room. Maybe I'll put everyone in. Let's see. Hang on. Okay, behaving differently now. So I'm going to place people into the room. Is there anyone in attendance right now that shouldn't be there? I think we have Walmart's attorney.
Yes, Your Honor, I don't believe I should be.
Okay. So we have Cub, should be good. We're not releasing anything right now. So I'll put all of PSC in the break room. It's not a break room. Renew, how about witness Cal?
No need for me to be there, Your Honor.
Okay. And Steve Heinzen, put you in there. I've already done it. So let's check back with this. And I need to be in there too. It's not. Oh, this is okay. So now this is the break room. No, it's not. Huh. Move to. So I see us. I see us in the break room, but I'm gonna start over. Okay. Well, since this is the last bit where I'm just going to turn off the live stream, and we'll just turn it back on. Because Mon may not be available. Mon, are you there?
Yes.
Are you seeing this that I'm seeing?
I have, since you're the host, I can't do much with breakout rooms. Let me try something.
Transfer it to you.
There you go. What about now?
That's bizarre. Okay. All right. So it looks like we're good. So there is a breakout room. Okay.
You're muted, Judge.
It mutes you
You're still muted. I can see your lips moving, but you're muted.
Okay, thanks. All right, so do we have any questions for witness Ritzma on the public corrections to his testimony? All right, nothing. Is this witness available for cross?
Yes, Your Honor, this witness is available for cross.
And so I guess we already got the answer to that. So no questions for this witness. I think that's all we need. So thanks very much. You're excused. So I think we have all of our witnesses accounted for. Anyone else for people in attendance? No. All right. So quickly wrap this up. We have directions for refiling and for creating new exhibits and for briefing. All that's wrapped into the scheduling order. Anything else we need to address while we're here? No. All right, great. Thanks very much. We will see you tomorrow. Next case. So get to work. I did want to mention, I haven't issued the offered evidence list and the 05 docket, but it's basically a copy of this one, except for whatever, minor adjustments occur between the applicants. So if we can be prepared for those questions, we can maybe get through them a little faster tomorrow. Besides that, thanks very much. We're adjourned.
Thank you.
Thank you.
Thanks.
Have a good night.